22 ming ko'ngilli volontyorlar faoliyat yuritadi. Advice.uz loyihasini yaratish bo'yicha mutaxassislar 6 oy davomida ishlashdi. Buning uchun ishchi guruh tuzildi. Ishchi guruh a'zolari citizen tanishish va davomida O'zbekiston uchun
Assalomu alaykum, hurmatli bugungi yig'ilgan forumga ishtirokchilarimiz. Men rus tilida gapirishga harakat qilaman. Международный forum bo'lgani uchun.
Good afternoon, dear participants of this forum. It is an international forum. Good afternoon, dear participants of the forum. Let's start our discussion session. Legal tech and legal tech perspectives and tendencies. This forum became a platform for the dialogue of the scientific society and people to discuss the current problems that we have related to economical and social issues, not related only to Uzbekistan, but worldwide. Today, participate in our sessions those who believe in the future and are working with Uzbekistan. Trust to Uzbekistan is a demonstration of our potential to the entire world. First of all, I would like to introduce people who are sitting nearby. It's Alisher Karimov, Deputy Minister of Justice, Dilshad Ashurov, the Chairman of the Notarial Chamber, and Furkat Tajiyev, Chief of the Legal Center Adolat, and I'm myself, Said Gulamov, as a professor of the Tashkent Law University. With your permission, I'm gonna provide you report. So with your permission, I'm gonna start about the transparency of the legal work. Good afternoon again. First of all, I would like to thank organizers of the International Intellectual Forum for the opportunity to provide such a speech. I'm going to talk about the possibility of digitalization of the court as a framework of the transparency for the legal work. Including the judicial system into the digital system, provide a country the flexibilities and a low cost. It is because doing it hand by hand, the digital technology is very adaptable and could be changed according current needs. As a part of our work, we provide analysis of the theory of transparency as a catalysis becomes automatization of the digital judicial system and using the AI, artificial intelligence, so would let us in practice to implement transparency, free access to judicial services, to shorten the dates of the judicial hearings. Okay, next one. Algorithm and how to do effectively is based on the AI and the AI platform software use as an online and a judicial simulator, the goal of which to check the document and to pass the document to the court and to expedite the delivery of the document and escort it to the judicial review. So this is how it's the court, the case is going to the court. The AI is helping to assisting and controlling. First of all, it's accept applications. Second of all, it's mediation, control of the judicial processes, and resolving of the problems of the higher colleague and implementation of the judicial decision. So first of all, acceptance of the application. AI functions accepting application from the person according to the legislation. The AI would forward the document asking certain questions and forward this question and will request certain documents that should be amended. All documents must be digitalized, scanned, digitalized, and attached. After the application fill out, the AI would accept, then send the documents for the simulator of the judge software, and then the applicant has a right for the refusal or the right for a review it further. Besides the application fill-out form, the AI also analyze questions, issues, why it get refused, to check all of the evidences, reason that it didn't help to fill out all of the applications, and send unfinished application to the criminal on the family-related cases to the law enforcement, analyze and provide statistical analysis and reasons that do not accept, that prevent for accepting applications, and provide information, entire information, and etc., etc., etc. So the next step is a mediation. As a statement together with results is sent for the review, and as a person would receive a certain date to provide the facts to the court, and those facts get inputted to the database of the courts, and then sent for the court for review, and also sent for this application. And this is what we call mediation, and helping to provide the court for the court mediation. Besides the procedure, mediation procedure, AI also analyzes the reasons that's prevented to fill out to accomplish the whole form, look all of the evidences, review all of the contradictions in legislation, help to uncover problems, and all of the problems, discover problems sent to the both sides for the review, and also control, the AI also control how is the decision implemented if they come up to a joint conclusion. The control of the judicial process using the AI in the court procedures. In a case if the one side is considering that the AI has technical problems, the one of the sides can request to review the case by the human court, in a human court, and then the court would make its own decision, base it and explaining what is wrong was with AI conclusion. If during this review it was a legislation contradiction found, and then court cannot come up to conclusion, then it's sent it further then it's passed to the higher colleagues, higher court, or if it's required for the two legislators. If during the judge review there are no big reason to change decision of the court, and then to put responsibility on the sides not to following the court decision. In the court process, the AI is first of all informing about the dates of the all procedures, checked all of the criminal side of the evidence is also could be act as a scientific advisor, also finding contradictions in legislation, and also sends the documents for the higher court if it's required, and informing of all sides about the decisions and the problems. The AI also conduct online monitoring in the higher colleague of judges, and also can recommend certain options to use the foreign legislation to analyze and summarize, and also to conduct a protocol of the and minutes of the court hearings. And the legislation act is put by AI in the database, and if it's the problem is found, it's sent for the further discussion and development to the legislators. Also, AI conducts the dates of how long is the case kept, and also provide information to all sides about problem resolution when it gets solved. I would like to during using the AI in the court, we having a new sides effects, new aspects, new positive aspects. First of all, it's a good prognosis using of the legislation. Next slide, please. It is a right for the based on the legislation without any human factor. What this means, when it's put the proper data, the applicant he has you have all rights to protect his rights following legislation. And in case AI would take opposite decisions, then the judge must explain his decision. And then the modeling right, the right for the free of charge consultation, just to modulate, just to forecast. The AI can forecasting certain results of the and provide a consultation, legal consultation on how to properly formulate the provide evidence. This database could be used by anybody, even those who has no legal background. It's a right for the peace of mind. The AI wouldn't accept any application if it wouldn't have enough proof of the guilt of the other side, because all of the facts is going to be checked during the inputting these facts into the system. So, at the same time, it is a defense from any applications that submitted during because of the hate or because of the so the presumption of the innocent is going to work for sure, because and it is what we call a peace of mind provided. The AI, artificial intelligence, would provide us to do the online translation, online. Online translation could be used as a mass media, and all interested parties, all stakeholders could participate in the online. It would help us anti-corruption policy implementation and to have a better decision by the court to remove all of the pressure to the court and court officials. So we have a new is a competition of the court officials. Next slide, please.
Kengisi anaqasi.
The competition of the court officials, court officials must compete with artificial intelligence. It means that in a court you must prove those cases that differ from the conclusions that AI come up to, and society is going to provide would get a right of the court officials' activities. It means that judges, court officials, gonna work constantly to improve qualification, to accessibility of the using the online applications. It's going to remove any borders of the legal between the different social groups. Automatization of the system and reduction of dates. Artificial intelligence would help to improve the similar criminal similar cases, which it's a commercial law, it's an agreement, it's a protection of the customer's rights. When there's taxes, payment of the communal services cases, all of the cases related to this, all statistical problems that do not really require the human participation. It could be done automatically. During the process to identify a problem and to send monitoring of a whole process and all of the legal accomplishments. Artificial intelligence will help us to track all of the activities and all of the steps, prevent and warn about the dates, deadlines, and to provide the transparency during the court hearings and accomplish and complete all of the court case according to the dates. So the risks of the transparency of the judicial, first of all, is a dehumanization when you use artificial intelligence in a court hearing. So it means we don't have a principle of humanism, principles that could be used by the judge, which is a part of the any case court hearing. So we shouldn't forget that all of the legal acts that are put into the artificial intelligence database initially actually made by people, by human beings, so based on the humanism. So it doesn't really matter if it's artificial intelligence or it's a real person as a judge making decisions. Limitless database analysis. Artificial intelligence has opportunity to provide without any preventions and to review all of the cyber process analysis and data. The artificial intelligence should be used on all phases of the judicial hearings. In all locations. The technical risks that we have, the artificial intelligence is automated system that is related to the information technologies, communication lines, software, electricity, and other technical means. We cannot accept that the hacker could steal the data, the viruses, some unsanctioned changes of the information, a lot of the technical problems and the human people factors. Using the artificial intelligence should be accent made, focus made on the cyber security, and we can put to track all of the illegal activities to use technical means to provide a certain level of security and safety. I would like to note that the traditional judicial system is not ready to accept and to use. In Uzbekistan, digitalization, virtualization is extending our procedure, and the court proceeding going to use it's require a new legal framework and a new technological solution. As example, it could be is new rights that could be regulated. Absence of the use of the artificial intelligence technological solution requires a big capital investments to creation databases, to creation platforms and frameworks. It costs a lot, and also maintenance of all of this. The people, those are not ready to accept IT changes. The current legislation have a lot of contradictions also with the use of the e-court systems and AI, and also we need to renew the organs and functions that's related to the, working with the e-court system. It means pretty much all branches of our. And also, it's impossibility to digitalize or scan certain evidences, for example, in a criminal case. And in the end, I would like to say we consider that those risks could be resolved, and because it depends on the funds and the funding provided and the society readiness, if we want to improve the system or not. As a final of the transparency court is development of the software of the online applications and simulator, court simulator, and the use of the e-court in order to provide a transparency that is based again on the information technologies and protection of human rights. Thank you again.
С вашего позволения.
With your permission, I would like to provide the floor of Viktor Naumov, and he is going to be online. He is a managing partner of the Petersburg office of the Dentons company, head of the Russian IT and telecommunication practice, co-head of the European Internet and Technology Regulator Practice Report, task of the codification of the digital legislation. So with your permission, the floor goes to Mr. Viktor Naumov, online report. Okay, who should be switched? Oh, he's not online? Okay. Okay. Since Mr. Naumov didn't connect to our system, so Gregory Vinjiran, president of the Law Society of Singapore, and his report is a legal tech, trends and prospect. So Gregory Vijayandran. The floor goes to, Amar Yunus Anso Scholar, University of Chinese Academy of Science, founder of Central Asia Tech Law, and his report, AI Laws and Policies in Central Asia, an overview of the Central Asia technology law and ecosystem.
So now I would like to provide brief information on the implementation of the system, as our moderator said, and he pointed out as to how important it is, and he also pointed out some issues in this area in the judicial system. In this regard, the Ministry of Justice has the enterprise Adelaide under the Ministry of Justice, and it works in this sector, and the very first steps of this enterprise have been made already. And 2 years ago we conducted this forum, and we raised this issue then, and we also highlighted several tasks in this regard. And on October 5th last year, we adopted a program called Digital Uzbekistan. And so we created information system on legal issues. And first of all, it aims at the small and medium businesses, and so that other individuals could also use it. And the legal advisors are trained in this system, and they can have an access to these documents, and there are over 450 documents, like agreements, applications, contracts, and so they can be accepted in electronic form. And if you visit the site, so you will find 6 sections, and the very first section is the judicial documents, which are related to court proceedings and agreements and contracts, and the third are corporate documents, and then some personal applications, and requests or inquiries. And this system was launched quite recently, and there was a presentation. And now I take this opportunity to provide this brief information about this. And now the floor goes to the scholar of the Chinese Academy of Sciences, the founder of Asian Tech Law, the international legal and the review of ecosystems and legislation in Central Asia. So the floor is yours.
Tushundim.
So now I would like to ask the head of notary chamber of Uzbekistan, Mr. Dilshad, what kind of information technologies we use in our notarial activities, and how can we upgrade the system which is in existence already? Thank you very much. Thank you very much. So now many knows that the notariate in Uzbekistan has undergone very serious changes, and the use of, in terms of using technologies and the application of technologies serves as a big push or impetus to us. For example, in the Ministry of Justice, we work with these organizations, and we decide to deliver more conveniences in terms of, say, like SMS messages, and when we receive applications from our citizens, we are trying to save their time, and through electronic notariate system, they have an opportunity to make an appointment with a notary officer and to arrive to the office at a specified time. And they can choose the time which suits themselves most. And they also update in advance on what kind of notary activity they will require. And so this is how they will reduce the lines and queues, and this is what we're trying to make the entire process more comfortable, and we're now refusing paperwork and paper turnover, and so we are now maintaining electronic database, and all these cases will be entered in the base, and we know what kind of notary offices, or what kind of notary office and what kind of activities they're involved with. And for example, if there is a selling of property case, and by the end of this case, the cadastre certificate may be issued directly from the cadastre, and they can just make a printout. It's a very convenient for our customers. And now speaking about corruption, in order to prevent corruption, the Ministry of Justice has established an SMS message system, and every person who deals with with notary officials, and if there are some fees or payments or customs fees or any other duties, so you should receive the confirmation through the SMS, and without confirming this, a notarial officer cannot undertake any work. And the Ministry of Justice has an opportunity to monitor all these interactions. So you have all the records available to the Ministry of Justice, and they can look into whether everything is being done legally. So they can closely monitor the entire procedure. And in future, we want to launch remote notariate. And so how I understand it, for example, in some remote parts of Uzbekistan, in Khwarezm or other regions, they are selling a house, like a property which is located in Tashkent, or a buyer is located in some other region of the country. So at the same time, they can work through the very same notary office being located in remote areas from each other. And so it's kind of they can make this deal, and they can receive prints out of the documents, and they can even electronically sign it. We know that when we execute some formalities, notarial formalities, the very first thing is that both parties should express their will, whether they do it voluntarily, and it should be certified by notary office. And from other countries' experience, we know that these things are being done. And so now we do everything offline. In Georgia, for example, they have this system. And they do all this through electronic, through digital form, and we need to know whether people are threatened to sign this document. Maybe they're gun pointed, and we need to make sure that everything is done voluntarily. And the major thing is we have the presidential decree on the prevention of conflicts within courts, so that courts would not interfere into the activities of notariate. And it goes without saying. And we also have pre-trial mediation court, and it really minimizes the burden on courts. And through automated information system of notarial activity, we can in real time to monitor all organizations, and all organizations can provide organizations and receive, can provide information and receive information, and the citizens will not go to all these instances to obtain the various pieces of information, because the entire information can be obtained in real time. So all the systems have been integrated into one, like marriages, and you can enter the system and learn what kind of services are available. For example, a person comes and he said that my marriage certificate is left at home, and then he can easily check it whether this certificate does physically exist. And a person say that I'm not married, you can check it easily. Or for example, death certificate is not available, but you can check it in electronic form, so everything can be monitored very easily. And currently it's not only us who do this. For example, our consulate departments of the Ministry of Foreign Affairs, because they are also in charge of some notarial activity for our citizens and services provided to our citizens abroad, overseas. And so we interact with them, and we interact Ministry of Foreign Affairs system with this unified system. And it's very convenient. For example, our citizens abroad will come to them for getting some notary services, and they can they can draft any legal document, and it really, in electronic form, it really save times. It can like you can check anything like property or cars which are being sold for prohibitions to sale, or initially before then. So persons need to provide all the justifications that there are no limitations on sales. Now in real time you can check if there are any burdens regarding this. And for example, you can also get residence registration information. And it provides so many conveniences to customers. And in future, one of the biggest issues, and it derives from the presidential decree, and you can do it easily in the places where you have this electronic booths, like in places like railway stations or airports. Sometimes people can provide some services, notary services, and receive notary services right from the airport. And in Azerbaijan, this system is very well established, and the major purpose we are introducing this system is to make our citizens' life much easier. Now there is a question concerning the information security. Could you please switch on the microphone? So the entire information as of today, meaning personal information in terms of cyber security, do you have any legislations in order to protect personal data, or we're using all the laws on storing data? So as to notary offices and security is confidentiality, and it is envisaged by the confidentiality, and all these personal things are well formulated in current legislation. The automated system of the Ministry of Justice focuses on security of personal data, and today, as I already mentioned, it is possible to obtain information which is collected only specifically for notary services, and the notarial officer bears personal responsibility, because this person personally collects these informations, and they have the power to provide notary services, and you can all the steps of these proceedings is saved. And in addition to this, by 2024, all documents which are stored in the archive will be digitized, and they will be available in electronic form.
Hello.
Okay, just let me know when I have to start.
We can't see you, but you can start your. Hello.
Okay.
Oh,
Yes.
hello. How are you?
Thanks.
hear
Thank
me?
you.
Can you hear?
Yes, I can hear you.
Yeah, you
Yes.
can
Let me start.
Yeah.
Okay. So first of all, I would like to congratulate to the organizers. Last year I was in Uzbekistan, and I knew that you were planning to organize this Tashkent Law Forum, but because of this pandemic we couldn't organize, but a lot of time, stamina and energy has been spent, and I really appreciate this. I am going to give you an overview of technology laws in Central Asia, and what is happening in Central Asia, what are some of the challenges, and what are some of my observations and some of the solutions. So I was talking about digital dividends. Digital dividends tells us that how the technology is impacting on the people's life. Unfortunately, we don't have a single study which can tell us that how the technology is impacting on Central Asian people. There was a study in 2016-17 which was conducted by World Bank, and this is the only study on digital dividends in Central Asia. So I call upon all the participants, if there are stakeholders, to conduct a study and calculate the digital dividends in Central Asia. This can be a very interesting academic study. But there are a number of projects which can give us a general overview of technology and law and regulations in Central Asia. For example, all the Central Asian countries, they have projects related to electronic governments. In Uzbekistan, you have Digital 21. In Kyrgyzstan, there was Tazacom, and then there is Digital 2020 and so on. Almost all the Central Asian countries, they have projects related to electronic government. Then all the Central Asian countries in different versions, they have projects related to smart city. In Uzbekistan, the famous case is this Tashkent city. Then all the Central Asian countries are very serious on laws and regulations related to 5G, because China is the only option from where we can import the 5G technology. So all the Central Asian countries are working on making laws and regulations so that they can accommodate this 5G technology in their own legal infrastructure. Recently, I have seen that there are a number of countries in Central Asia, Uzbekistan as well, working on individual privacy and data protection laws. And then all the Central Asian countries, now they are very serious about e-commerce and regulation laws. Some of the countries, they have individualized special laws for e-commerce regulation. If we talk about challenges related to tech law development in Central Asia, first of all, there are so many buzzwords. Academicians, politicians, policymakers, journalists, they listen these buzzwords from internet, and then they quote them in their own media. And if we talk about how these technologies are being accommodated in our political and legal system, I would say that there is no intellectual infrastructure. This Tashkent Law Forum, I think that is one of the very first attempts to talk about tech law and legal tech in Central Asia. But previously, individuals were working on these issues, but there is not a formal intellectual infrastructure. Universities are becoming serious about introducing courses related to technology law and legal tech, but formal attempts are lacking. Similarly, if we talk about ideas, mostly the ideas are imported. Some scholars who have been studying in Europe or USA or China, when they come back to Central Asia, they try to incorporate those ideas into their own legal and political system. Sometimes they fit into their context, and in majority of the cases, they don't fit, and they actually become a trouble for existing laws and regulations. So there is a need to work on contextualized laws and regulations in Central Asia. If we talk about policy challenges for digital transformation of Central Asia, I have divided them into two types of challenges. The first is citizen-oriented challenges. You can talk about capacity buildings of the people. You can talk about a very common debate in Central Asia, which is about privacy versus security debate. We know that recently, almost all the Central Asian countries, they imported facial recognition cameras. In Tashkent Metro, we have installed facial recognition cameras. In other countries as well, they have been using these facial recognition technologies for monitoring and security and for traffic. And there was a debate that are we willing to compromise on our security, on our privacy, on the cost of security. If we talk about on policy level, a huge amount of money has been spent in buying these artificial intelligence cameras and digital and on the process of digitalization. And this money, I think that was spent more than what was required. And one of the main issue is that we are not working on producing the similar technologies, but we feel ease in importing these technologies. So when we import these technologies, it gives a chance to the local politicians, policymakers, and general populate to talk about that, why you are just buying, why don't you produce, and then the issues like privacy versus security erupt. If we talk about institution-oriented challenges, the vulnerability of data is being produced in Central Asia, and it is being held on clouds which are outside of Central Asia, means the data is vulnerable. Recently, some of the governments in Central Asia has tried to make laws related to data protection in Central Asia, but still there is a challenge of cross-border digital security because it is compromised. When you buy technology, you don't know where the data is being stored. So these are two categories for the sake of understanding what are the challenges. Then there is a very big challenge of digital content. Digital content is being produced in Central Asia. Digital content is being imported by Central Asian people, but there are not many laws and regulations related to digital content. You know, the buying and selling of digital content, everything is on internet. The buying and selling of this digital content is not being regulated in Central Asia. So some of the scholars in Central Asia, they are working on cyber civil law. There is a Grajdansky Codex, but I have talked with some of the scholars that they want to introduce separate cyber civil law. I think that this is very innovative, very progressive, but how it can be incorporated in current legal infrastructure, it might be a challenge, but this is a wonderful idea that if we have a civil law, a civil code, and then we have a separate cyber civil law, if you are unable to incorporate technology in your existing civil law, then you can have a separate cyber civil law. If we talk about AI and Central Asian society, artificial intelligence is a very sensitive topic in Central Asia. There are a number of layers. There are a number of dimensions to look at artificial intelligence. Some of the colleagues were already talking about it in the previous session. There are religious issues, political issues, social issues related to artificial intelligence, and sustainability as a whole is a challenge in Central Asia when we talk about artificial intelligence. There are a number of regional and international actors who are involved, who have kept an eye on this region, and they are willing to invest in artificial intelligence, but without having proper rules and regulation in this region, I think that it will not be an intelligent decision to give contracts related to artificial intelligence to the investors who are willing to invest in this field. Then this artificial intelligence has a huge chance to be exploited by policymakers and the politicians as well, because this is a disruptive technology, and this technology has the potential to interfere the existing political infrastructure. So in future, those politicians who have more grasp on the substantial matters related to artificial intelligence will have more advantage in taking leads in this region. So technopolitics is something which should not be neglected when we are making new laws and regulations related to artificial intelligence in Central Asia. So what I proposed to different governments in Central Asia that all the Central Asian countries, first of all, they should have their own national AI policy. Now, when I talk about national AI policy or artificial intelligence policy, I don't specifically talk about artificial intelligence only. I give AI as a reference to technology. So all the Central Asian countries should work on making their own national technology policy or national AI policies. Uzbekistan has recently launched their own AI policy. Some of the other countries are also working on this. So national AI policy will give a roadmap to all the stakeholders that they should work with technology as per the rules and regulations mentioned in this national AI policy. And it is also pertinent to mention that Central Asia is a region, and Central Asia can come up with their own Central Asian AI policy. We know that the European Union is working on European Union level. America has made their own AI policy. Chinese have their own AI policy. Some regional instruments are working on their regional AI policies. Central Asia can also come up with their own Central Asia or Central Asian AI policy to contextualize the new innovation technologies with Central Asia. I think that this is something on which all the stakeholders should work in Central Asia, because the issues are same, challenges are same. So this Central Asian AI policy will give a contextualized, a very good contextualized information for all those who are willing to invest in technology in Central Asia. I wrote a paper recently in which I talked about nomadic AI principles. AI principles or artificial intelligence principles represent the technology regulations and the ethical challenges related to the artificial intelligence. All the universities, they are coming up with their own artificial intelligence principles. I propose that Central Asia should come up with their own Central Asian AI principles, so that the people who are dealing inside Central Asia with technology, or outsiders who are willing to invest in technology in Central Asia, should know that what are the ethical demands of this region. So I think that this should be taken by the policymakers and should come up with their own AI principles. I am advocating this Central Asia tech law. European Union, Chinese, Americans, they are working on their own technology laws to make it more relevant with their region. So I think that Central Asia should also think about Central Asia tech law, and all the stakeholders, especially the academicians, should start propagating this idea that there is technology law, but Central Asia has its own demands. So Central Asia tech law is something which should be, I would say that, taken seriously, because the demands, academically speaking, the demands of these regions are different from other part of the world. So I will conclude with these three big questions. These questions are for all the participants and for all the stakeholders to think upon until we meet next time in next legal forum. The first question is that all the Central Asian stakeholders should think that how we can use law to incentivize new technologies. It is very important because usually in Central Asian region, when someone come up with an idea, or if you have to register a patent in intellectual property office or the patent office, it becomes very troublesome for a scientist. So the law should facilitate these new technologies. And this is the question, that what sort of new laws we should make to incentivize new technologies. We shouldn't stop new technologies. We should make laws which should incentivize new technologies. And the second question is that how we can use law to regulate new technologies. I gave a number of examples like facial recognition cameras or 5G technologies or cloud computing in Central Asia. How we can use law to regulate, because the current legal infrastructure is not sufficient. So this is something on we should work, that how we can use law to regulate new technologies. And finally, it is a bottom-up process as well, that how the technologies can be used to make new laws, because there is a huge communication gap between the applied scientists and legal scientists. I think that both stakeholders, the applied scientists and legal scientists, should come and sit and discuss and talk about their own concerns and reservations and come up with ideas with consensus. So the question is that how we can use technology. It is not always law which promotes technology. Technology can also be used to make new laws. And for this purpose, we need to decrease the communication gap between different stakeholders. Thank you very much for your attention. If you have any questions, we will discuss in the discussion.
Thank you very much for an informative. Спасибо за столь содержательный доклад.
Thank you very much for such an informative speech, I would like to note that Uzbekistan is also developing legislation in the artificial intelligence, and the President Decree PP 4936 so on how to improve AI technology into the life and 17 February of 2020. So besides this, we have another legislative act. I think that your achievement would help us for the development of international legislative creation in the area of AI. Thank you very much for your informative speech. The next speech is going to the legal technology trends and getting started.
Great pleasure to deliver this presentation on behalf of the Law Society of Singapore in this prestigious forum. The Tashkent Law Spring is fast becoming and accelerating towards a premier law forum in Central Asia. And my presentation this afternoon is entitled Legal Tech and the Trends and Prospects that are available. I'd like to take the opportunity to also congratulate the Uzbekistan Ministry of Justice and the organizers of this prestigious forum for this feather in the cap and for persevering despite the challenges of the global legal pandemic. Now, I think I will need to share my screen with all of us so that we can follow the presentation proper. So if you can just bear with me for a second. I don't know whether my screen is visible. It appears it is not.
Yes, it is. You
Never
can
mind.
see it.
You can see it? Okay, brilliant. Thank you so much. It's not visible from my end. The legal profession is being disrupted, and the rate of change is of a magnitude that has taken many by surprise. As the legal technology vision prepared by the Singapore Academy of Law correctly notes, lawyers are standing at crossroads. You can resist or ride the tide of disruption in the legal profession and choose whether or not to implement legal technology in your law firm. What started off as an interruption is now a disruption and will soon become an eruption. And COVID is only exacerbating the impact. Now, I begin with a reference to what is legal tech. And if we begin with definitions, legal tech refers to technology that enables and augments the delivery of legal services. Businesses or law firms that employ legal tech use technology arbitrage at the center of their business module. And essentially, they monetize the value of technology in order to be able to gain the optimal value from that technology. In other words, to try and monetize it. Stanford Law's Codex Tech Index classifies legal tech firms into 9 major categories, and you can see that on the screen. Legal practice management, legal document automation, e-discovery, and so on. I won't go through that in detail. The question for the legal professions of the world today is, what does legal tech mean in a practical sense? It provides new opportunities for the profession. It enables legal service providers to enhance productivity, but the disruption that I spoke about and the rate of it could pose new threats to the profession. According to Gartner, by 2024, in-house legal departments will have automated 50% of legal work related to major corporate transactions. And by 2025, at least 25% of spending on corporate legal applications will go to non-specialist technology providers. Now, we know, I think from our respective jurisdictions, and Uzbekistan is also riding this wave, that there's a greater acceptance and adoption of legal tech. And as we see the rise and evolution of technology in areas such as artificial intelligence, that Speaker Amar Yunus just addressed us on, the sensitivity of AI, as well as the Internet of Things and cloud computing, these are transforming the way law firms are competing. And whether it is the government or end users like law firms and in-house teams, stakeholders have taken strides to embrace and launch initiatives to advance the use of legal tech. And the COVID-19 pandemic has been a watershed in the partnership between justice and technology. Now, related to that is a real-life concern that cannot be ignored. It is a counterbalance, and that is cybersecurity. As more law firms of different sizes venture into this area dominated by technology and data, cybersecurity will become a key talking point within the profession. Due to the sensitive nature of data that law firms possess, law firms need to ensure that they have a robust cybersecurity plan that is capable enough to protect the data. And we need to ensure that the data breach incidents that have taken place in other industries such as e-commerce, banking, finance, transportation, and so on are kept to a bare minimum in the legal industry. Building digital trust will be the key to the adoption of new technologies. Now, we then go on to the changing nature of work in the legal industry. The skill sets needed for lawyers will evolve, with tech-related skill sets and soft skills being the main focus. This will result in a greater investment in human capital for lawyers. There will be a talent competition between various industries, engineers, technologists, data scientists, as well as the legal profession. And one of the areas that have been identified by futurists is the role of legal technicians. That this will replace some of the older jobs, and it will be a new job that will enable lawyers to work intelligently with technology. So not displaced or replaced, but man plus machine. And so in that sense, as smart contracts, virtual properties, driverless vehicles become the new norm, clients may rely less on lawyers for services such as document review or project management. And an American study revealed that AI software is able to achieve 94% accuracy when reviewing a sample of non-disclosure agreements, compared to 85% accuracy when a team of 20 corporate lawyers undertook the same exercise. So this is a harbinger of things to come. And we need to see how to move upstream and also create new jobs by way of the legal technician role that I mentioned. Legal tech will continue to be shaped by global trends, and there will be a changing demand for different types of legal tech. The rise of technology giants and the impact of the global pandemic has reshaped consumer behavior. To give you two simple examples, working from home has become the norm for many. And that, of course, becomes the impetus for harnessing technology so that lawyers and various members of the legal industry can work intelligently, efficiently, effectively from home. Tech has also been the great leveler to ensure that we see a greater harnessing of female talent, as well as those that may be challenged physically or mentally in our workplace environments. And so it is the great leveler and also the great inclusive agent to ensure that pockets of prior unemployment or suboptimal employment are now engaged in a greater way than before. The growth of demand for legal services in the Asian market will also shape the type of legal tech solutions available in the market. We know that e-commerce is growing in a phenomenal way, and many of us can attest to that. The way in which we ourselves have shopped online, have ordered services, ordered products online. And this is only going to grow exponentially. Now, I'm not going to cover all my slides here. I'm just going to skip past a number of them and focus in the limited time that I have left, because I want to show you a video of our Techcelerate for Law, which will give you a visual appreciation of the Singapore journey. Now, let me just round up quickly. There is obviously a greater cost pressure and competition for law firms with the rise of alternative legal service providers. One of the big issues that we are tackling in Singapore is identifying what are the regulatory pain points for lawyers in Singapore that are hindering them from becoming innovators. And we need to relook antiquated rules and traditional barriers that are preventing our lawyers from competing at the same footing or equal footing as the alternative legal service providers, so that there is a level playing field all around. And this will also be conducive for innovation. I'll take you to slide 15 of my slides. This is a foundational study we did in 2016, just before I started serving as president. And this has formed the base for much of our projects and our operationalization. Our findings, based on a deep dive study, showed that going paperless and running a virtual office will reduce 2/3 of the operating costs. Sharing database of precedents and past case knowledge by way of a knowledge management repository provides about 40 to 50% time savings. And we all know that time equals to money in a lawyer's office. We also discerned that there was a critical gap in innovation, and time fails me to talk about why. I've already given one indication that there may be some antiquated regulatory barriers. But law firms do need to grow in terms of business acumen, and this is the piece that we are paying attention to this year with a Business Development Day. Now, I'm going to round up very quickly. I won't cover all this material because you can read them. I will share the slides with all, but this was the project we started in 2017, Tech Start for Law, a public-private partnership, up to 70% funding support from the government that set aside $2.8 million for lawyers to incorporate technology by way of baseline solutions. The sequel, which just ended, Techcelerate for Law, and which you're going to see a video presentation on, saw the government of Singapore set aside $3.68 million for lawyers to adopt baseline and advanced technology solutions. So to go to my last slide, this is the roadmap of what to expect in the future. Going forward, there will be a legal industry technology and innovation roadmap that will roll out even more industry transformations and initiatives over the next 2 years, which will include a legal industry digital plan to provide law firms with practical assistance to assess their digital readiness and identify digital solutions to adopt at each stage of their growth. I remain grateful to the Ministry of Law, and you've already heard from our Minister for Law at this August gathering, and he is one of our outstanding thought leaders who is committed to seeing this digital transformation. And one of the visions is the second bullet point that you will see there, a legal tech platform initiative that can aggregate plug and play solutions to help law firms manage core services, set up and coordinate and provide service bundles by practice areas. In the words of the second Minister for Law this morning, technology waits for no one. And so my hope is that the audience listening to this presentation will continue to ride the wave and not be at the crashing end of a tsunami. And on that note, it's my privilege to share with everyone here a video presentation. A picture paints 1,000 words, and I shall leave this video presentation on Taxcelerate for Law with you as I close my presentation. Thank you very much for giving me this privilege to share these remarks this evening. Thank you.
Thank you very much, Mr. Gregory. Спасибо за столь содержательный доклад.
Thank you very much for such an important presentations and the precious efforts in application of digital technologies in courts of Singapore will provide us the opportunity to go through this very complex way in this in the legal industry. Now the floor goes to Miss Gayatri Raman. Gayatri Raman. Tendencies. Gayatri Raman, Managing Director for Southeast Asia, LexisNexis. Thank you very much. Спасибо большое.
Honored to be here. Thank you very much for having me and giving me the opportunity to share my story and my journey and the journey of LexisNexis with you. It's great that I'm following Gregory. Long time no see, Gregory. Otherwise, if it wasn't for the pandemic, we would be meeting more often. I am based in Malaysia. I'm the managing director for LexisNexis for Southeast Asia. So I used to travel to Singapore pretty often. Just a little bit of context. The Southeast Asia region is comprising of 10 ASEAN countries. And today I will be speaking a little bit about what LexisNexis does globally, legal technology trends globally, as well as a specific example or a story about how Malaysia started its legal tech journey from the beginning in 1932 to today. I joined LexisNexis in 2001. So whenever I'm sharing the evolution of legal tech from the printed material to what we are offering today, for example, I have lived through those experiences and that evolution as well. And definitely to echo what Gregory has said, the speed at which legal tech has risen and developed and evolved in the last 3 years alone has been incredible. It equals the last 30 years in the world. And if we don't ride the waves, we are going to be left behind as legal professionals. I fully believe that technology is an enabler, and the combination between law and technology is extremely powerful. Who are we? We are leaders in legal technology. We have we operate in 130 countries around the world. We basically take legal content, laws, primary laws, secondary laws, and then put it in formats, these days in technological format that is consumable by more and more people, but not just these days, it's also understanding it, slicing and dicing it as well, so that people can dive deep the legal information that is out there and get better insights to inform legal discussions, legal dialogue, legal strategies, and legal execution as well. So The last point here in this slide, you can see that it says our network contains 3 petabytes of legal and news data. That's 150 times the size of Wikipedia, right? So you can just imagine that. And I call this particular point out because it is extremely important to get the data right first before we talk about using technology to deliver solutions to the legal profession, for example. And the legal technology that we at LexisNexis specifically employ is, I am very conscious of what Amar earlier had cautioned people about artificial intelligence and the speed at which technology may be developing, for example. But the kind of legal technology that we employ in artificial intelligence, machine learning, is natural language processing, using technology to translate languages, using technology to understand what the language is and make plain language versions of it, using technology to summarize, understand context. So it's all about language because we are trying to enrich the legal information that we have. Okay. So this is a chart that documents our evolution. This is a global chart that we have and we constantly share with people. You can see that on the left-hand side of the staircase, it is the products and the names of these products. So they are called Lexis Advance, Search, Term Maps, Lex Machina, etc. On the right-hand side would be the technology behind it. We began with full text search, then semantic search, then data visualization, trying to describe it properly, now predicting it, predictive analytics, and machine learning and cognitive computing. So our journey as well has evolved, and it will continue to evolve as well. This is Lexis Plus. It is a product that was launched in the US. We don't sell it in Malaysia, for example, but it is a product that uses artificial intelligence, machine learning to analyze case law, analyze judgments, judicial decisions, judges' trends, litigation trends as well. And you can see that it goes by attorney, it goes by law firms, it goes by courts and judges as well. So this is a technology that has been adopted and launched in the US. Why I use this is I wanted to talk about globally what we are doing first, and then I also wanted to then share what we're doing locally in Malaysia when I say local. And it is important. Gregory spent some time earlier with several slides of his talking about how to catch up. And I must say that in jurisdictions where the government and regulators like the Law Society, Bar Associations, Ministry of Justice supports it, puts a blueprint together, puts a plan together, puts funding to it, it is extremely beneficial to the society at large. And I commend the Singapore government for having the foresight to doing that as well. Where you don't have that, not every jurisdiction will have governments putting funding like 3.6 million in there as well. When you don't have that, then we need to also embrace organic developments in technology that is happening on the ground. That is also can be a fantastic way of developing legal technology within a jurisdiction as well. So don't discount that as well. So now my Malaysia story. Malaysia gained independence from Britain in 1957. So 50 years of colonial rule. It is a common law system. It's modeled after the English system. In Malaysia, there are about 20,000 legal practitioners. So these are lawyers, attorneys, and they are governed by the Legal Profession Act. There is still a combination of practitioners who are still relying on manual legal research tools. There are many practitioners who go back to the books. They have physical libraries. They rely on reported cases in bound volumes as well. And we, LexisNexis, also produce content, legal content, primary law, case law in printed format, in a book format as well. We in Malaysia, LexisNexis in Malaysia, we produce something called the Malayan Law Journal. That is the oldest and most comprehensive law reporter in the country. And the Malayan Law Journal cases, you can see here in green, these are the bound volumes where some lawyers are still using. But we also now apply artificial intelligence, machine learning into case law and created online digital versions of it, as well as analytics of cases as a result of having this data and cases in our database as well. So it's gone from printed, which we still produce and we still print in warehouses, in printers, etc., to Lexis Analytics, which is driven by semantic search. It is driven by natural language processing as well. And I'd like to share how that journey has evolved over the years. Who we are in Southeast Asia today. We are known for delivering content in many different jurisdictions across Southeast Asia. We have offices in Malaysia and Singapore. In Malaysia, we report the case law. We are the oldest, so we are #1 in legal research tools in the country. And we also were first in making online research possible in Malaysia. And we have 81 billion documents in our database. The latest and most exciting, because I have been in the company since 2001, we are a 100-year-old technology company. We evolved from print, and this year, in January, we deployed and launched Lexis Analytics, which uses and is powered by AI. So that evolution is something that I would share in my next slide as well. As you can see, I always take pride in the fact that the company was founded by someone named Bashir Malal. He was a court clerk in 1932. At that time, no institution, not the judiciary, neither was the government, compiling case law or making it available to anyone at all. At that time, no one had access to cases unless you argued that case. So what he did was he saw the need for the rule of law. He saw the need and importance of transparency and access to laws, and he began compiling cases. So he published and reported the first case law in Malaysia. Then you can see we started the MLJ, so from a printed version in CD-ROM version. So we would sell these CDs, people would put it into their computers, it would be updated every quarter, and people would get latest cases every quarter as well. Then we started digitizing them more and put it online into the cloud. And people would then key in their IDs and passwords to access case law online. I was hired to teach judges and attorneys how to use the online platform to access case law and educate the market on awareness and the acceptance of technology such as this, because at that time there was skepticism. People didn't believe something they couldn't touch. They preferred the books. Then in 2012, we launched the case citator. This enabled people to know whether the case was overruled, whether it is still good law, or whether it is followed by subsequent cases or not. And the last few years, we have been building and creating something called Lexis Analytics, and that is using deep learning, using natural language processing, using really AI, and putting it into our product. So that has been the evolution. What is it? It is new. It is not available. It was not available in the market at all. It is something that we envisioned. We worked with lawyers on the ground in Malaysia. We spoke to 170 separate lawyers in 1-hour sessions to understand how they were planning and strategizing their litigation files and cases. Then we started building the product. We in Malaysia did not have to think about being envious as to what the US or LexisNexis in the US had. It is fully created by the Asia team and my team here in Malaysia. What it is you, a litigator, an attorney, copies and pastes a brief from your client. You put it into the system. You don't have to do anything with it. You don't have to type. You don't have to put connectors. You don't have to do anything. You copy, you paste a whole brief. You put it into the page here that says, and then you click on Analyze. Immediately, the system, using artificial intelligence and context searching and semantic parsing, it takes and pulls out legal issues from that brief. Once it pulls out legal issues from that brief, it gives you also issues that are related to the brief, but you didn't type it in. It goes into our database of thousands of cases, the Malayan Law Journal cases, and it gives you a graph on the far right as to how many cases talk about which legal issue at a glance. You don't have to narrow down, go to the second page, do anything like that. Then it tells you how strong, how much of a good law is the case that you're arriving at. It talks about historical outcomes. So it is something that immediately saves a lot of time, but it is deploying technology to do the work of many people, multiple dozens of researchers, legal researchers in a law firm in order to do that. However, it is not that easy to go there. Remember, we had to start with getting the printed version into the digital version. So it's not as if we can just deploy artificial intelligence and technology to everything. It is very, very important that we understand that access to data is key. We could do it for Malaysia with analytics because we had access to the case law and we could use that to develop the analytical tool. We'd love to do it for Singapore, Gregory, if we can have the Singapore law reports as well. But my point is, digitization is the key. And why I say that is because I do live and work in a region across Southeast Asia where legal technology and technology in the legal justice system is at various levels. Not all of us are at the Malaysia level, not all of us are at the Singapore level. Some of us are at a level where everything is in a paper format, and we need to use technology to support that and start somewhere. We have done this for the Maldives courts, the Maldives Attorney General's office, and also the courts in Myanmar as well. So the key here is to get that content in the printed format, digitize it into digitized format, and then put it in a way that technology can be used on it. So that's extremely important. Because legal tech is about the law, the source of this data will most likely come from the government. Legislation, case law, case data, all of this will come from the government. So we need to support the government in their efforts to digitize this data before legal tech can take off. That is the first step. Our priorities have guided our journey in legal tech. Specifically in Malaysia, it is all about solid data and content and using that as an enabler. So many things about the points about benefits of technology acting as an enabler and a leveler, which means letting everybody compete at a level playing field without having to invest lots and lots of money on it. That is true. So it is something that all lawyers and all legal professionals can embrace as well. these are my concluding remarks. We have many countries and many jurisdictions where we are at different parts of the journey, but this formula stays really true. We have to make sure that we have integrity of data. That data needs to be in a format that the technology can operate and work on. And then we need to make sure that we use that data to advance justice and the rule of law. Thank you very much. I'll be happy to accept questions later when the moderator allows it. Thank you.
Спасибо большое за столь содержательный.
Thank you very much for such informative report, Madam Romans. Thank you. The use of the information technology, the LexisNexis software, which is a trend, is a main trend, and have important. It should be used in Uzbekistan, considering the national interest. With your permission, I would like to pass the floor to the next reporter, Jae-Sung Lee, the UNISTRAL legal officer of the UNISTRAL technological development and the need for the new rules.
Thank you. I hope you can hear me.
Oh, yeah.
First, I share my slide.
Yeah, we can hear you. Hello.
Yes, I'll start.
Yeah, we can hear you. You can start.
Can you also see the screen?
I can see the screen.
Thank you. It's with pleasure that I'm representing UNCITRAL at this international legal forum titled Tashkent Law Spring. My name is Jae-Sung Lee, and I function as the secretary of UNCITRAL's Working Group 2 on Dispute Settlement. I'm based in Vienna, Austria, and as you can see from my title, the focus of my presentations will be focused on a specific area of law, or laws on international arbitration and mediation. Body says laws on dispute settlement. And I would like to address the question of whether we need new laws or new rules to respond to and prepare for technological development. Now, earlier this year, after much hard work, Uzbekistan adopted a new law on arbitration, which was based on a model law promulgated by UNCITRAL, the United Nations Commission on International Trade Law, which I work for. As some of you may be aware, UNCITRAL is well known in the area of dispute resolutions, but its scope of work is a lot broader. In 1966, the United Nations General Assembly established the Commission on International Trade Law in response to the need for the United Nations to play a more active role in removing or reducing obstacles to the flow of international trade through the progressive harmonization and modernization of international trade law. Therefore, the area of UNCITRAL's work stems from international contracts, legal obstacles faced by micro and small and medium-sized enterprises, transport, secure transactions, insolvency, as well as judicial sale of ships. Of interest to you today, maybe, is its work on electronic commerce, beginning with the model law on electronic commerce, which was prepared by the Commission 25 years ago in 1996, but still being adopted by many states. But today, I would like to focus on arbitration and mediation. It can be said that the international arbitration framework is solidly grounded on UNCITRAL texts, beginning with the 62-year-old New York Convention, which provides a mechanism to enforce arbitral awards across borders, and which now has 166 state parties. Uzbekistan joined the Commission in 1996, and the UNCITRAL model law on international commercial arbitrations, which has influenced a number of arbitrations around the globe, including Uzbekistan's recent law, was initially adopted in 1985 and amended in 2006 to address the issues arising from the writing requirements in that law, which pose challenges with the development of electronic communications. In commercial contracts, you also find references to the UNCITRAL arbitration rules, a comprehensive set of procedural rules upon which parties may agree on for the conduct of arbitral proceedings. UNCITRAL has also produced guidance documents, such as the Secretariat Guide on the New York Convention, the notes on organizing arbitral proceedings, and the recommendations to arbitration institutions on how to conduct arbitrations under the UNCITRAL arbitration rules. In parallel, UNCITRAL has worked towards establishing an international legal framework for what we call commercial mediation or conciliation. In fact, I'm very pleased to say that the Singapore Convention on Mediation, which was adopted in 2018, provides a cross-border enforcement mechanism for mediated settlements similar to that of the New York Conventions. And that convention entered into force last September, only 1 year after it opened for signature, which is indeed a remarkable achievement. It is our hope and expectations that the Singapore Convention on Mediation will rise to the position and importance of the New York Conventions has achieved for the arbitration. While the success achieved thus far is truly extraordinary, it is equally worth noting that for the conventions to fully reach its potentials and effect, we must continue our efforts to invite more states to ratify and accede to the convention, including Uzbekistan. Along with the convention, the model law on international commercial mediation was updated this year, and this year, during the annual commission session, it is expected that the revised mediation rules, the UNCITRAL notes on mediation, and the guide to enactment of the model law would be adopted, which would complete the legal framework for international mediation as well. One of the working groups of UNCITRAL focuses on formulating laws relevant to dispute settlement. That working group, which is an intergovernmental body where state representatives participate and where Uzbekistan is also invited to participate as a member of the United Nations, has focused on establishing new rules on expedited arbitration, which we define as a streamlined and a simplified procedure with a shorter time frame to achieve final resolution of the disputes in a very cost and time effective manner, while at the same time preserving due process and fairness. The expedited arbitration rules, which is also expected to be adopted by the Commission this summer, are rules that parties can agree on for the conduct of expedited arbitrations, and it will supplement the general UNCITRAL arbitration rules. One key aspect of the expedited rules is that the tribunal is expected to render an award within a 6-month time frame, with an exceptional possibility of extending that time frame to 9 months. In addition, there will be certain new requirements in the notice of arbitrations and the response thereto. For example, that you have to include a proposal for the appointing authority and the appointment of a sole arbitrator, a simplified process for designating and appointing authorities, a default of one sole arbitrator, mandatory consultations with the parties, the possibility to not hold hearings, limitations on counterclaims, and evidence to be in writing. Now, in preparing these new rules, which are supposed to be adopted this year, the working group took into account the recent developments in arbitration, including the impacts of COVID-19 pandemic in the realm of international dispute resolution as a whole. These included immediate measures taken by arbitral institutions from across the world to respond to the COVID-19 crisis. In this regard, you will probably agree with me that arbitration practice has changed dramatically due to COVID-19. And you may have heard articles or read articles on the increased use of digital technology to facilitate the conduct of arbitral proceedings, including the use of online case filing tools, the conduct of remote and virtual hearings, the adoption of digital authentication signature process for rendering of the awards. And while remote hearings are not new, the pandemic has caused its use to proliferate, and there's great interest to maximize the efficiency of the arbitral proceeding through the use of technological means. Now, However, the use of technology in dispute resolutions has itself resulted in disputes. Just as an example, the Austrian Supreme Court rendered a decision last year in which one of the parties challenged the tribunal members for their decisions to hold a hearing remotely in light of the travel restrictions at 3 p.m. in Vienna, which was 6 a.m. for where the parties and the council were. In the end, the Austrian court rejected the challenge and confirmed the tribunal's power to hold remote hearings, though it's a very difficult time for the parties. Similar issues may arise with the increased use of technology in different stages of the arbitrations. Now, even before COVID-19, there was discussions about the use of technology in the arbitration process, mainly for holding case management conferences, for hearings, and taking evidence. The question discussed by the working group is whether such a rule, a specific rule, should be provided in the expedited arbitration rules. One view was that such aspects are key to expedited arbitration and should be expressly mentioned. Another was that the arbitrary tribunals already had that discretions under Article 17 of the Institutional Arbitration Rules, which, as you see on the screen, state that the tribunal may conduct the arbitrations in the manner it considers appropriate, provided that the parties are treated with equality and given a reasonable opportunity to present its case. Now, in the end, the working group agreed to include the language that you see on the screen, which I hope you can see. The new paragraph emphasizes the discretions provided to the tribunal to make use of a wide range of technological means to conduct the proceedings, including when communicating with the parties and when holding consultations and hearings. It also mentions that consultations and hearings can be held without the physical presence of the parties or remotely. Now, why did we decide to include such a rule? The inclusion of such a rule aims to assist the tribunals in streamlining the proceedings and avoiding unnecessary delays and expenses, both of which are in line with the objectives of the expedited arbitrations. It also avoids challenges made to the award rendered using such technological means. However, the tribunal should be mindful that the use of technology is subject to the principles for fair proceedings, and they should try to give each party a reasonable opportunity to present its case and also to present their views on the use of technology. As a whole, we hope that this rule would facilitate the use of further technological use in arbitrations, and this is why the working group decided to include a specific role in the expedited rules. This is not the first time that the UNCITRAL embarked to formulate international legal standards relating to the use of technology in dispute resolution. As mentioned, the model law on arbitration was updated in 2006 to reflect how writing requirements are to be met. In 2016, as you see on the screen, the Commission prepared the technical notes on online dispute resolutions, or mechanisms for resolving disputes through the use of electronic communications or other information and communication technology. While the technical notes was to be used for disputes arising from cross-border, low-value sales or service contracts concluded using electronic communications, or as we call it, online trading, it had its limits because the government could not agree on how to address issues that arise from those disputes that involve consumers. So what now? As mentioned, UNCITRAL, as I mentioned, is an intergovernmental body, is working to develop legal standards relevant to the digital economy, issues that the previous speakers touched upon. The working group is preparing a legal text on digital authentication, on how to meet those, make sure that these digital authentication methods are used cross-border. And the Secretariat is continuing to develop a legal taxonomy of the different concepts that the previous presenters mentioned, like AI, what is mentioned by automations, data transactions, platforms, as well as digital assets. We are organizing colloquiums to refine the scope of these topics for future work, and including dispute resolutions in the digital economy. The Commission is also considering a proposal put forward by the government of Japan, and that the Secretariat should conduct research and compile information on the latest trends in international dispute resolution. And in that context, we organized a panel last year on how international dispute resolution would likely evolve as a result of COVID-19, noting that the crisis had actually already accelerated changes that would have taken years for us to develop otherwise. The Secretariat is looking at the long-term impact of such development. We will likely witness a variety of innovative measures in dispute management in the future, such as increased digitizations, as the previous speaker mentioned, further use of technology, expedited procedures to adapt to the digital economy, where it can simply not be envisaged to wait 9 months or even 6 months for a decision to be made, the use of AI, asynchronous hearings, and online platforms, which should all contribute to the shaping of the future international dispute resolution landscape. The emergence of digital tools, such as AI in dispute resolution, also lead to changes in the ways how future legal professionals and arbitrators are to be trained. Simplification and relaxation of formal processes to enhance the time required for dispute resolutions will likely become the norm. However, despite all possible future developments, as I have highlighted before, we must not forget that the fundamental principles of dispute resolutions or arbitrations, including party autonomy and the discretions provided to the tribunals while conducting the arbitration proceedings, should be preserved. Also, the due process and fairness should be preserved. Now, another development that I'd like to mention is that we are embarking on further discussions on online dispute resolutions at the Inclusive Global Legal Innovation Platform on ODR, which is being hosted by the Hong Kong Department of Justice. The objective of the platform is to keep track of the developments in and issues arising from the applications of emerging technologies on online dispute resolution. And the forum is to facilitate continued discussions, and we'll discuss this issue, the question that I'm addressing today, whether we need new rules to facilitate the use of technology. The platform would explore, discuss, and develop innovative legal tools to address novel issues from the use of ODR and facilitate the harmonization of any new rules to be developed. Now, the Secretary will be providing the Commission with information about these recent developments and suggest work that can be undertaken at the international level in the future. The main components would be the use of technology in traditional disputes, remote case management conferences, hearings, and taking of electronic evidence, resolution of technology-related disputes, including those arising from data transactions and fintech, and online dispute resolution platforms, as well as the role of AI in dispute resolutions. With that, let me conclude. And I hope by now you have an overview of what's going on in the International Legal Forum at Tashkent, and agree with me that the technological developments may need to be accompanied by legal developments or the development of new rules, whether it is for regulatory purposes or for facilitating the use of technology or enabling trade in the future. Let me reiterate that it may be worth your time to carefully look at what's happening at Tashkent and keep alert of the new developments being discussed at this international forum. And many thanks for your attention. Thank you very much.
Спасибо за столь содержательный доклад, уважаемая Джейн Сунг Ли. Поднятые вами проблемы применения информационных технологий в арбитражных разбирательствах свидетельствуют о неуклонном развитии международных стандартов в сторону облегчения бремени разбирательств бизнесу. Надеюсь, ваши предложения найдут отражение в национальных законодательствах наших стран. Теперь, с вашего позволения, хотел бы предоставить слово нашему первому докладчику, Виктору Науму, управляющему партнеру Санкт-Петербургского офиса Дентон, руководителю российской практики в области информационных технологий и телекоммуникаций, соруководителей европейской практики в области регулирования интернета и технологий. Доклад называется «Задачи кодификации цифрового законодательства». Пожалуйста, Виктор.
Very nice. Good afternoon, dear friends. I'm happy to welcome everybody, and I would like to sincerely thank for the opportunity provided to present on such a well-reputed international forum. And in my presentation, I will talk about the issues related to the logics of the development of legislation and law in our digital era. And with your permission, I would like to show one presentation, and I hope it will be shared on the screen. At least I can see myself and my slides. So, and in this presentation, I will indicate some viewpoints which have the rights to exist in the conditions of those mass processes of all penetrating of digital transformation, which lead us to the new stage of the development of humanity. With this, I would like to mention that depending on national specifics, depending on the level of penetration of technologies, technological culture, and the customer or user culture, the ways of forming of national legislations, regional agreements, and the system of regulation in general, in terms of international institutes of law, public and private, in the area of digital transformation, they could be different. With this, we realize that everything related to digital transformation is a complex category which objectively discovers many types of technologies. Okay, you can see it on my slide. I was really concerned with this slide. In fact, we're now encountering a big number of specific planets when technologies and digital technologies and transformations and new industrial revolution determined absolutely new by its nature social relationships. And the key thing is the issue of processing big data, because we're getting more and more convinced that the information collections on subjects and objects becomes more comprehensive, and nothing can hide from processing big data and related to what's happening in the world. And under the collection of information, the specific contour, or say planet of industrial internet of things, one great deal of sensors enabled to create copies or twins in digital world. So what happens in the material world? Previously, we didn't encounter things like that, and more frequently, we're surrounded by individual transportation means in many countries of the world, and it actively phases out classical public transportations, and during pandemics, the leading sector in terms of implementations of implementation of digital technologies is telemedicine. And of course, during the recent decades, we are actively developing legislation on the introduction of these new technologies in fintech, in financial activities. So new technologies which determine new content of financial activity, and they're becoming more and more popular. And it needs to be emphasized that those trends and solutions which are made in terms of regulations, specifically in Uzbekistan, and the society, citizens, and the state have the demand for the construction of the unified digital environment of trust, where in terms of remote communications we are able to identify objects and subjects, and protecting communication channels we receive the information which is veracious, and we can trust all those activities which take place in the digital space. And the list of this planet is not full, but if you look at the speed how they penetrate in our life in many sectors, so those areas are of priority for us. So what law can offer in these conditions for very new type of social relationship which phase out classical relationship related to material world? One of popular trends is to create experimental legal regimes when we eliminate barriers of old legislations to give space to the development of new public relationship. Starting from fintech toys in Southeast Asia to special regulations of telemedicine in Europe and the United States. It is quite natural that new technologies require sometimes very new legal solutions when the content of law norms is determined by technological reality, where it is impossible to find some analogies from our past. Classical example is the AI, which is undoubtedly displaying a new spectrum for the development, and it hides many dangers within itself. And the system of, say, OSCE, EU, consider things of limitations of technology, AI technologies in highly specific areas, very sensitive for human rights and citizens' rights. But anyway, these novel tools are quite obvious, and they're still penetrating. And the third type of possible instruments and solutions for the formation of a new law of the 21st century is the possibility of codification of legislation, or the possibility to systematize legislation in the form of codification. And even now, several countries of the world, in the Eurasian continent and in other regions of the planet, have started working on digital codes when understanding that there are new public social relationships appearing, and they provide systemic solutions for this process.
Such a priority is in the regulation in the public relationship. We consider it as a part of those legislative initiatives that may begin to get more popular in the world. As they underline that at least at this point, no country could demonstrate as a fully digitalized code related to the digital economy and digital transform. There is informational code, there is a model documents, but there are no such a thing as a digital code yet. Some countries, they can take they can implement it in a close future. In this public relationship related to the individual transport is the Internet of Things. This is something that should be regulated, and a database, it's big data. It also should be work with the cybersecurity shoulder to shoulder, and we understand that those calls that's related to the new technologies in the area of the implementation of new technologies are pretty substantial, and especially in the big data analysis. We, international companies, internet business, government, we get more and more to the identification of the subject of relationship when you do not have personal information, but using the big data analysis, those identification is occurred so as a part of the technologies, and the subject of the relationship is not warned about such a risk and such a as a volume of defecation, partially or full defecation. It is a key issue that's related to norms. In order to use a public relationship in order for the big data. So you should consider that not everything that's happening with informational technologies and digital technology could be used for the good thing. There are situations that's causing substantial or sometimes it's a new risks and situations. To the number of priority relationship we need to put as a separate to the form of the new digital. In order to develop documents, we need new requirements and new responsibilities as for the infrastructure and for the all participants that organize and participate in this relationship. We can see everywhere in the world on the low grass level. When we can get misinformed about the text and information provided, but also related to the audio and video information delivered through audio video means. So the person pretty much do not have opportunity and again to get information, proper information, to identify where is the real information and where is the real actually person behind the information, or it's just a bot, an automatic machine. Also, the legislative initiatives that's happening in the world. We can talk about the financial technologies and the telemedicine. If we were gonna walk in the way to form a digital code, then this road has certain pros and cons. As one of the cons, we can relate that the traditionally codification or code creation happening in the in a time when the big amount of the legislative act are created, and it doesn't help, but it's actually opposite. It disorganize the work and to use certain solutions. For example, in Russian Federation, more than 20 different codes exist, from the classical civil code, a criminal code, a processual code, and also some specialized code. It's a forest code or a water-related code. But considering the really fast-changing area of information technology, I consider that we need to work ahead of and concentrate the main norms of related to development as a one big document, one big volume. Of course, considering there are certain small areas for regulatory activities that could be provided permission on the level of the special laws. If we consider the model for the scientific study, maybe scientific discussion of the digital code, then yes, the key is to identify area of the responsibility and terminology, because all countries in the world there is no system approach to systemize because all stakeholders, with the state stakeholders, courts, they facing a problem that there are no single the worldwide recognized terminology of the legal definitions that could provide adequate legal implementation of the certain activities and areas. Unfortunately, it haven't been created yet, and the single terminology for a digital economy is one. It should be one of the pros of the systematization of the legislation, again, as a part of the codification process. Another what we should pay attention to is the digital world. Everywhere has digital information exchange. In the old terms, we talk about the electronic document flow, but now the technological reality is the relationship of this is getting more complicated, and the matters to identify the jurisdiction, to trans-border communication, to the blocking to the access of information. So it's a part of the digital technologies that's used by the modern world. And another important aspect and the subject for the regulation is digital platforms. You know, we live in a new political realities when there's a substantial influence causing not only countries, governments, businesses as a classical material world, but also internet giants, those companies of the internet companies as a part of implementation of the local documents, actually causing changes, causing effect on the many people living on our planet. Digital platforms also use to build a digital platform of trust that should be a separate part and a separate complex of issues to identify the legal issues. If we review the model of the regulatory models as a separate department, is how to organize the public management of the digital economy, which particular public departments should be responsible, and which particular should be responsible and which volume. And if we see right now what's happening in the different countries, we can see it's pretty big variety of solutions on how is the management, how is the government create a special ministries on digital development, or just divide the special issues to each classical pre-digital ministries. Also, quite popular is a problem related to not only with the industrial internet, but with creation of the smart city categories. Human societies will use in the close future, not only for communication, but also infrastructure that's in a principle new, that's create a new living conditions for the human. So the new digital rules that's applicable for the managing of the smart city. Another topic is digital code, is also intellectual traffic system, transportation system. In addition, this is another topic, informational security. Unfortunately, we still review the processes when you jump in a swim, when you jump in a sea of digital technologies, we forget about and sometimes don't even understand the basis, what could be done, or what is dangerous, what's dangerous to do in the digital ocean. And in this, the role of the social regulatory organs is right. It should be protecting digital freedoms of the citizens. Another topic that could be also could be related to the codification and could be related to digital code but from the technical point, is not really related to the classical informational relationship. It is a point of the public-private partnership. I understand that that is happening, and it's pretty much happening in Uzbekistan. It is not a codification problem, but it's a creation of the special codes, considering the digital. Right now, the governments in the whole world have no means to create those all necessary digital platforms, but at the same time, they should be using the digital solution, to provide the social duties to the citizens, and the cooperation in this area between the government and the business as a part of the PPP. Those become a tool that became more and more popular, including into the area of the digital economy. At this point, I would like to close my presentation, and if any questions, I'm ready to answer. Thank you very much for such an informative report. I think in Uzbekistan, we're going to consider your opinion. And at the same time, now we have also in Uzbekistan scientific researchers done on this topic. We're thinking about developing cyber code, civil code, and other codes, and as a part of the AI that's going to be regulating in the area of the informational security, the cyber rights, the digital rights, and I think within 3-4 years, Uzbekistan will be fully form legislation related to this topic. Again, thank you very much for your report. So now is the question and answer session. So if anybody have any questions, please go ahead. So we don't have any questions so far. Okay, we have question, right? Good afternoon. Good afternoon, dear participants of the forum, distinguished speakers. Thank you for your presentations and lectures. For me, as for the lawyer, is very helpful to learn about the legal tech and the law tech. I have a question to Mr. Gregory Vijayendran. Please introduce yourself. My name is Bizimat Azamatov. Mr. Gregory Vijayendran, in your presentation you said that more automatization related to the legal work, and in this relations I would like to ask you a question. By which level do you think we can automate the activity, the work of the legal profession? And what do you think that the legal professionals can lose their job because of the AI implementation? So thank you. If other speakers have any their own opinion, please, I would like to hear your opinion as well. Okay, Mr. Naumov, please. I can answer if we don't have a Gregory. So, first of all, the question is addressed to Mr. Gregory Vijayendran. Gregory, are you here? But I will use the opportunity. I would like to share with you. I consider that at this point, the legal professionals have nothing to be scared of, because automatization in the first place is a touching of the commodities. It's a topical operations. Now is we don't really have the strong artificial intelligence that could be compared with the professionals, legal professionals. In any case, the big data analysis and using the AI in a big data analysis, those what we talk about automatization is happening on a pretty good quality level, and the implementation of these technologies becoming mass accessible, and a threat for the profession of legal professional could be for those who provide a technical, really specialized, maybe just for analysis, or maybe just to double check certain paperwork. But if we talk about the complicated development, legal acts, or judicial work, at this point the technology cannot replace the legal professionals. But without a doubt, that's a number of people, professionals that get involved in the legal professions. It's going to be reduced. Automatization, the math models, and the artificial intelligence is going to compete to the significant number of the legal community.
Спасибо большое, господин.
Thank you very much, Mr. Naum. I would like to add also that information technologies day by day is gonna come to our life, and more and more. And I think it's pretty soon we're going to be working in a virtual life with legal professionals. We need to work on who we should prepare. Who is a legal professional? Those who knows law, or those who can implement properly the legal documents in a digital format. So now it's going to be automated approach. That's if you graduated from the institute. So the institute university should be preparing the professionals. It's so if you need to find to search information, we just simply search Alex Us or some website. You don't need to remember it. You can use a modern technology to find it. So we need it's already automatization. It is a skill to apply, it's a skill to use those knowledge. Then you can be competing with AI and information technologies. But it is going to competition, to the area of competition of legal professionals. Do we have any more questions? Do we have any questions to any speaker? I'm Suhrab Yusupov from Ministry of Justice as a moderator. As it was said already, the low tech. That is the creation of these technologies. Are they legal professionals? Our moderator mentioned that the creation of the artificial intelligence, it is related to the algorithm of work. It is writing the implementation of the algorithm, the practice in which practice he has. In which particular matters the legal professionals need to participate in this process? So, the legal professionals, the jurists, need to study the computer software, create software, or how we can put programmers and legal professionals, it should be interdisciplinary cooperation to create a good and properly working software. I would like to hear your opinion how we can do this. I think I will try to answer to this question. And at this point, the programmers or the legal professionals should be involved in the software development. I think it should be interdisciplinary. It should be joint approach, and In other countries, and again we talk about it is as a complex development, because you cannot review the legal aspect as a single one. It is useless. Working together with software professionals, development of the AI and the creation of related software, it's going to be done by programmers, because the legal professionals won't be able to learn the programmer knowledge. And I tried. It's really difficult to combine, and we need to find people from the youth and just develop them those skills. But it is difficult again to just they already doing it in Europe, South Korea, when they find in the States, when they find a child who on an early stage can create a very original software. They need to invest in this child. They need to invest in him. They need to save him. And in our countries, this area is just in the development. We have a lot of the young people that's capable. But again, the legal professionals that's working with the programmers need to indicate them the limitation of the. But the artificial intelligence self-development program, that you cannot stop it. It's could be developed indefinitely. So it should be joint work of the legal professional and the programmer. First of all, the legal professional explains a single language, which particular language it should be written on, and then it's put him some limitations for his software, so the AI shouldn't cross certain borders. And the third one, it's our national legislation. It also should be. We don't have a single vocabulary for the algorithmic language, and again the programmable language that we would use in Uzbekistan. They use different languages. Different companies use different programs and softwares. And now we just accept a strategy for preparation for the AI and implementation of AI. So I think one of the points, I don't remember which particular paragraph, we talk about which particular language to pick for that all our state authorities would use in their software one single standard. So this is artificial intelligence that we're gonna put, it would work in one system.
Maybe foreign expert would like to contribute to this discussion.
I just understand the question to mean who will program and write the codes when you're talking about legal tech. Did I get the question right?
Yeah.
Okay, so I will give you some examples. At my company, we have a combination of people. Our editors also can write the code, and our editors are content experts, and they are legally trained people. They are attorneys who we hire, who work for us. But we also have developers and engineers. These are people who write the program just like any other tech company as well. And this group of people are the ones who write the hard code on all the latest technology for legal tech. So we can think about it in different types of legal tech. If legal tech is definition or digitization, for example, then it is something that more people can take on. If it is something like machine learning and natural language processing using the latest technology, then we need real computer software engineers and engineers to do it, to develop it as well. So my short answer is it depends on what kind of technology that we are exploring and creating, and what kind of code that needs to be written, and then that can inform the different kinds of people who writes the actual coding. Thank you.
Thank you very much, мадам Роман. Еще вопросы будут?
Any more questions? Good morning, my name is Ahmedova Gulnara. I would like to express my heartfelt gratitude to the organizers of this event and to all the participants as well. My question is to Amar Yunus, and I would like to hear the opinion of other experts because foreign experiences is of crucial importance for us. And my question is, the COVID-19 pandemic enabled us to realize big advantages of digitizations of legal services. For example, people can remotely, without physical presence, to receive various legal services, and they became more accessible. For example, here in Uzbekistan, we have an information portal which is called Advice Us, where citizens can absolutely free of charge operatively receive legal assistance. And it would be interesting about foreign experiences, so how pandemic impacted or just influenced on the development of online legal services in respective countries. Thank you.
Буду рада.
First of all, thank you very much for the question. I just want to summarize my view on the previous questions as well. There was a question related to that the future of lawyers. I think that this question is also related to that question. When we talk about automation of legal profession, many things have already been automated. For example, in 2019, there is a famous case in Chinese city Guangzhou, when the judge was a robot and the lawyers of both parties were also robot. So this was a setting that you are in a cyber court and the judge is also a robot and the both parties are also being represented by robots. So this is something which is extraordinary when we talk about developing new techniques, tricks, and skills for lawyers, that in such settings when both parties are being represented by the robot and the judge itself is a robot in a cyber court setting, what we will do. So I think that the lawyers should work on their prediction skills, and also they should work on their judgmental skills, because this is something which robots cannot automate. With regard to the question related to that who will design the codes, in Uzbekistan, we know that there is a very famous project which is already being implemented. It is 1 million Uzbek coders. So 1 million Uzbek coders in Uzbekistan is a project to teach coding to everyone who is interested. This 1 million Uzbek coder program is teaching coding to everyone as someone learns a foreign language. So no matter what field you belong to, what area you belong to, you can learn this coding as you learn any other foreign language, and then you can use these coding skills in your own profession. With regards to the pandemic, there were some very positive outcomes of technology, but at the same time, there were so many challenges for the lawyers that how we should incorporate. For example, the drone comes to your doorsteps and bring medicine of your choice. And this drone at the same time is the subject of aviation law, or some other countries, they are making new laws related specifically to the drones. So now this is a disruption. The benefits are there, and the policymakers, they have to, judge that either they should focus on the legal part or either they should look at the pragmatic importance of this part. So Internet of Things is one of the examples. What is Internet of Things? Internet of Things is that the things can communicate with each other by using internet. So it is also possible that there are no potatoes in your fridge, and fridge automatically, refrigerator automatically order this to store to deliver it to your doorstep, which comes by drones. So when the things will start communicating among themselves, there will be many challenges related to the civil law, the contract law, and this is a disruption for our legal field, but we cannot neglect that technology is beneficial. To conclude this, I will say that technology is moving at a faster pace and law is trying to catch up. So it is the job of lawyers and the policymakers to catch up with these new technologies. I would also mention, because Mr. Azam Madaminov is sitting here, last year he was working on a development of a new civil code, and I know that the scholars were struggling very hard that how we can make this new laws, which is the new Grajdansky Codex of Uzbekistan, more relevant to the contemporary world. And at that time, we engaged all the stakeholders, in which technologists were there, the people from other countries who had already incorporated the new innovation technologies in the civil code, and we tried to include some preambulatory clauses in the new civil code. So I think that this new civil code is a great achievement of Ministry of Justice of Uzbekistan. Thank you very much.
Thank you very much. Еще вопросы будут?
Any more questions? Good afternoon, Yuldasheva Shahidahon, Ministry of Justice. And my question is to all the participants. I'll be happy to receive an answer. Mr. Naumov, in his report, mentioned that the development of technologies is providing great effect, overwhelming effect, and we are lagging behind the development of technologies in various parts of our social life. And they also represent a great deal of issues and problems like personal security, inability to bring to responsibility for certain violations on personal rights and personal data, distribution of fake information, spreading fake information, and it is very difficult to bring to responsibility persons guilty in dissemination of fake news, because they can delete their sites and it will be difficult to identify them. And this is why internet stores are very popular now. Of course, there are very many legal internet stores, but there are very many groups in social media which sell their commodities and stuff, and all these sales are not taxed, and the income received is not subject to tax. So my question is to all our presenters. In order to develop technologies, it is required to apply a great deal of endeavors, time, efforts, and material investment. But why legal responsibility lags really far behind the development of technology? We understand that changes in legislations require certain time and they are subject to various processes and procedures. And similarly, technological development also takes time. Why technological development goes far beyond our legislations, and so why we're lagging behind, not only in our country, but in many other countries of the world. So what are the major reasons for this? Maybe the technology development has its own material interest, vested material interest. Maybe this is the answer. Please, your contribution. Let me start. It's a very interesting question, and the discussion is very interesting during our Q&A session. In fact, from my viewpoint, the reason is because is in the nature of law and legal activity. Law as a social regulator deserves its authority for thousands of years. Due to the objective conservatism, it's kind of reference or ethalon which shows what is good and what is bad. With this, the law, depending on the situation, is very close to ethics. Law and ethics are two regulators which for years and years, for thousands of years, have gained very serious reputations. But when now technologies are developing exponentially, the law objectively cannot develop that fast and cannot catch up with this technology, because the logic of development of the law, there is this inertia and special cycles of social lawmaking and public discussions and stuff of some specific rules. Unfortunately, it's a very serious issue for the law, because the law entered the 20th century under the conditions of systemic challenges, 21st century, sorry. And there were new sectors appeared, new challenges appeared, like the use of atomic energy, for example. But there were these were narrow fields, which of course affected the destinies of humanity. But now, in all spheres, we're trying to transfer to digitization, and the masses of these changes are very, very, very serious. And this is why legal science should very expeditiously rethink the system of principles and approaches towards lawmaking activity. We can say that the law should learn how to live in a changing world, and it should propose not concrete relations, but in order how to regulate these changes. But it's a very, very, very complex construct. When we look at theoretical principles, it is very conservative. If we look at the sectoral division, it is also the same, and the law should change. But it's a very difficult task, and I don't know any successful examples, theoretical or social jurisdictions, where could be taken as the basis to demonstrate that a specific country or specific sector has responded successfully to new challenges. So it so happens that the entire world, we are not only competing each other, where it's not just a race, but we are trying to catch up the train of digital transformations. We are the lawyers, and the question is whether we will manage to catch up with the last car. This is the issue. Thank you very much. Thank you very much, Mr. No, for your response. Я хочу сейчас вмешаться, потому что у меня была небольшая проблема. Я согласен с тем, что сказал.
Mr. Amar Yunus mentioned that the law has to catch up to the legal development, but law will never catch up. It is actually, the laws are there to facilitate these kind of the use of technology in different legal transactions. And that is why one of the key principles that underlie the UNCITRAL text on electronic commerce and any text that will be developing in the digital economy is based on the notion of technology neutrality. Now, by regulating or by actually specifying certain technology to be used for these transactions, in the end, these technologies will be outdated. And it might actually be not facilitating, but it might be ending up as a regulatory tool to actually regulate any and prevent any innovations. So I would suggest that while the law has to catch up, we have to make sure that the laws that are enacted are based on the notion of technology neutrality to facilitate future innovations in the future. And I think that is something that we have to bear in mind.
Thank you very much. Thank you very much. Ну что, есть еще вопросы у вас?
Any more questions? as Speaker correctly mentioned, is a very specific area, specific issue. But if you, it is not the law which appeared first, but social relations appeared first, and then regulations under certain law. If we look at the developments of the last 2 years and pandemic itself, and the relation have been strengthened due to digitalization during the last 2 years, and the law will always lag behind, and the more it lags behind, the new challenges we will be encountering. And of course, the lawmakers are encountering encountering big issues. So the wider this gap is, the more challenging we will be encountering. And the question was perfectly correct, why the law lags behind information technologies, and it was correctly said that this is the problem of lawmaking and weaknesses of lawmaking, and very retarded responding to things happening around us. And as our deputy minister said, that first relations appear and then they need to be regulated. I always propose to regulate and then create relationships. So we need to create such a code which could prescribe all relations in advance, which have, say, appeared in Japan, Europe, United States, but in Uzbekistan which will come with such delay. And the question was really correct: why can't we create our own digital code in advance, or cyber code in advance? Because we have very big gaps in cybersecurity issues, and we don't have legislation on cybersecurity. We have some measures to protect data, but it's not cybersecurity in totality. We don't have special requirements to cybersecurity, and I would propose to our lawmakers to develop in advance, not to catch up with the problem. So when there is relations forming and we encounter some issues, we try to solve these emerging issues, and we don't want to create environment in advance for our businesses, for our citizens, so that they could develop in a certain direction which is regulated already. Since we don't have legislative basis for this, everyone develops in one zone way, and we have a lot of information centers being opened now, and business incubators, and now we have information incubators.
They're making programs, the special products for citizens, for society, for the legal entities, even for the government. And so the interesting things, they don't have any legal framework that they would conduct their work in Uzbekistan. They don't have any legal authority. So they're working just using a general civil code that's get outdated, and they use certain legislation that's been developed in 2000s, in the early 2000s, and one of the big accents that the president is called Year of the Digital Technologies. So now the informational technology series developing fast. So if we're gonna be using this tempo that we took, so I hope in the Republic of Uzbekistan we can form a significant amount of the legislative acts, legislative documents that could be applied to the digital technologies. Thank you. Do we have any other questions? I think it's already time. The organizer is showing to me that we already exceeded time. Let me summarize in the end this session that we held today. So, to summarize our discussion session, legal tech and law tech, trends and perspectives. Today we heard opinions of our international experts in the information technologies and legal rights. As we can see, a need as developing of the legal documents as a part of the improvement society and the protection of human rights. We hope that the scientific practical proposals of the speakers would affect the national legislation legal documents creation. I would like to thank everybody who participate, and additionally to thank the initiator of the Tashkent Law Springs, personally to the Minister Uslanbek Davletov and to his professional team for the arrangement, organization of such international and significant event. Thank you for your attention, and hopefully see you soon. Shaking hands, applause. Thank you.
Yeah,
I guess. Yeah.
No.
So I guess they will have translation, or?
I understand they're going to have simultaneous translation. So I think areas where you can, translator can simultaneously translate without you having to wait, but that's what I've been told. So fingers crossed.
Because I don't see translation option on my screen. You see translation option on yours? Because sometimes it is available as an option. You can turn on or turn it off. But I don't see on this screen. Perhaps translation is not, for us at least. For me, it's not available.
But for our panel is all English anyway, no?
Yeah, panel is English, but the audience.
Well, it is also a lesson learning, language learning exercise of sorts.
Hello to everyone. Hello. Would have been wonderful if we were all together, face to face, in a room.
Indeed. In one room.
In one room, yes.
Pandemic live, isn't it?
Yeah, strange.
Hello, everyone. I'm the last speaker in this session, joining you from Brussels.
Last? I thought I am the last. Is it? Yeah,
no, I'm the last.
Okay, then I have a different schedule. It shows I am the last. Anyway, we'll see.
We'll see.
1750 is my time.
Yeah, and I'm 1805.
Ah, all right. There is a session. Yeah, okay. I don't see it on my screen actually. The schedule they shared, so they don't have that on the schedule. So 1805. After 1805 on my schedule, they have a question or answer, and that's close of the session. So they added a session, I guess.
Must have done.
Yeah. Okay.
Actually, do we have to show slides? Because with 15 minutes time, I mean, why do I need to show them in the first place? I think it's...
I'm not going to do slides. I find with Zoom meetings, slides interfere with the communication, unless there's something specific to put up on that you want to put on the slide. Oh, Tashkent.
I've done slides now.
I won't use slides anyway.
Yeah, I have slides because they asked me to prepare slides, and I shared the slides, and I don't know if they have circulated those slides.
I don't think they have, but I prepared slides as well because it was a request. So
yeah.
Well, we'll all see, won't we? Let's just see how this all goes.
I would rather stick to the plan. If you have slides, then.
No, it's also that, the plan can be sometimes deficient when people, for example, don't have enough experience of doing these kind of conferences, because when there's 15 minutes time, what's the point of overloading the senses with all this visual information, right? But, well, we'll see. All I want is that there is option, no slides as well, because,
Well, I'm not using slides, so there is the option. So I think it's choice, huh?
Karim, to your point, looks like there is some people translating who've been called. So it looks like there'll be translations in Russian and Uzbek.
So there are around 8 sessions, right? 15 minutes each. what I see on the schedule. No?
1, 2, 3, 4, 5, 6, 7, 8 speakers.
Do we have a sense of how many people there will be in the audience? Hopefully at least the 8 of us, but any more?
No idea, but I will confess to you all, I'm from the Government Digital Service in the UK, so I'm coming from a very pragmatic, government digital services creates openness and transparency. So I'm not quite, it's going to be a bit of an odd fit perhaps, but hopefully it will work.
Yeah, so well, that ties in very much with my sense of as well of the benefits of technology, and obviously, what's left for humans at the end of it is the the mercy, the justice, the sympathy part of it, which AI is struggling at the moment to achieve. But almost every other element of building trust and confidence in the system is better done by technology at the moment. And so I think that the digitization of the process to do what computers do best whilst leaving what humans do best to humans ties in with what I'm saying as well.
Well, one would hope. Well, we'll see how it all meshes out, shall we?
Well, that's why I'm always mindful of that lovely story of the speaker who started off with an audience, room full, and after 5 minutes, half of the people left, and after the next 5 minutes, the remaining people left, and there were sort of 10 people in the audience. And after about a quarter of an hour, there was just one person left in the audience who was listening attentively and nodding. And after the half an hour, the speaker realised that that was probably the end of it, and walked down and said, "I'm really pleased because everybody except you left, and I was very grateful that you stayed to listen." And the guy said, "Well," he said, "it wasn't through choice. He said, I'm the next speaker." When we used to do conferences in the Middle East, certain speaker profiles, they will talk well beyond their time. They just have their 500 slides, and they're not going to stop until they get to the end of it. And there's a device that we used to have on the stage, and it pointed only at the speaker, and it emitted this horrible, shrill, screeching noise. But because it was unidirectional, only the speaker could hear it. And as they got 5 minutes past, it would turn on, and it started this irritating noise in your ear. And then it would go up and up to the point where it was almost impossible to stand on the podium. And the audience didn't know what was going on because they couldn't hear it. What we found, though, is if you're over 60, you can't hear the bloody frequency, so it didn't make a blind bit of difference. So it only works on the younger speakers.
So that is something very new, actually. I have never heard this device.
Yeah.
Typically, what they do is that they allot you the time, and they have some coordination in the background to make sure that you don't overstay. You don't have 500 slides.
So, Jude, are you looking out at a beautiful blue sky today?
I am. It's lovely.
Yeah. I know.
Here in DC, it's very chilly. It was summery a few days ago, but back to very chilly weather, very windy and chilly.
Yes, it's all happening in DC at the moment, isn't it? Well, at least according to the BBC, everything here. There's a lot of progress on many fronts.
Yeah, there is. Yeah, especially on the vaccination front, quite immense improvement. feed. Almost everyone in my circle is getting phone calls or text messages that you should schedule an appointment. And most of the people around, they are telling that, oh, I got the shot, first shot, second shot. So it's very, very rapidly spreading everywhere.
Is it free to get the shot?
Yeah.
Gosh, it's almost as if you're erring towards universal healthcare. Could you imagine what a disaster that would be for a country?
Yes. Yeah, if you could afford it. Because who doesn't want universal healthcare?
Well, my sense was that
affordability, no?
Well, I think America's doubled the amount of dollars in circulation in the last 12 months with no perceivable impact on the value of the dollar. So in that sense, it just seems as if you can afford whatever you want.
Yeah, true.
But that's probably not a discussion for today.
Well, sounds very much like, but I have promised myself not to start my office hours from reading the news because this is impacting my performance.
True.
So I'm granting myself half an hour of news at the end of the day because otherwise it just doesn't make sense.
And then can you sleep afterwards?
Do you know, we're meant to be starting at 12:30, aren't we, exactly?
Раз, два, три, английский канал. Меня слышно? Раз, два, три, раз, два, три. Вы меня слышите, нет? Раз, два, три, раз, два, три.
To you all, I'm going to have to leave fairly early, so it'll be a hello and present and depart. I'm sorry.
Are we meant to stay on for the full session? That message hadn't quite got to me yet. But if we are, then we can make it happen.
There was no instruction, I think, but it's also that I can see that some people are speaking on other sessions as well. So I think that some rotation is envisaged.
I have to go do another event in 2 hours, so in 2 hours I will leave.
They have a question answer session at the end, which is quite long, actually, 50 minutes or so. So which means that they are expecting at least some of the speakers to stay and respond to the questions. No?
They may have pre-nominated the speakers they want to stay and excluded those that they think might be troublesome.
At least I'm not the one pre-nominated.
Yeah, nor me. I would have thought that it would be lovely in Tashkent at the moment in terms of the climate. Yeah.
Really? Mm.
We do quite a bit with Kazakhstan, and the spring and the summer are absolutely wonderful. But the winter's a bit savage. I left the airport. Yeah. I arrived one November. I walked out. It was minus 50.
So there are people in the room. At least I can see around like maybe 40. 30, 40
That's incredible.
Right? Yeah. There is social distancing. There is a distance between the chairs.
And do you think they've got people in the room and they've got people dialing in as audience?
Yes, I think so. Because I understand that there is this sort of like audience room, and And then we have the participants online as they prefer to participate online.
There's a chap called Oybek who's sending me
Someone is
questions.
asking a question, but I am not entirely clear what he wants to ask about. Do you have an idea?
Participation in construction, like in building, right?
Yeah. So the concept of shared participation in construction. What is that?
So what does it mean exactly? Like two companies would pull together their resources and then apply for it, or what is meant by it?
I don't know.
No, this is precisely not clear because the question in Russian is asks about the equity, and the question in English says shared participation, and I got lost on this, to be honest. So
Where do you see the Russian version?
the Russian version is in the question and answers, and in the chat we have the English translation, and the English translation talks about shared participation. So
I think it starts off, dear speakers, can we ask a question not on the topic? And then it goes to a the question in Russian, and then it's the question in English translated.
yeah.
If someone is not too lazy, please write your answer in writing.
Google Translate gives to this Russian concept equity participation, but I wouldn't frankly even know what exactly it is.
Yeah, no.
I wonder if he means the concept of a consortium bid for large-scale projects where you might have, the civil works bid out of two, and you might have, say, the rail works bid by, Alstom or Bombardier. Maybe he means consortium bidding for infrastructure projects.
And then the answer is yes, it is widespread, right?
It is everywhere. Yeah, everyone does that.
Well, but I'm not sure, but perhaps the question is about how the access to the market is being regulated. Because what I have observed, it sometimes does happen that you have to have a subsidiary registered in the country, or you have to own a company in the country to be permitted to compete for public contracts for construction. This is definitely the case in Kazakhstan. This is definitely the case in Turkmenistan. In Uzbekistan, I don't know because I didn't have the opportunity yet to see it on one of the bank's transactions. But we have, but we have seen it in other
господа, прошу.
Dear gentlemen, ladies and gentlemen, with your permission, let's start our session. There's a session that's the topic of our discussion session is digital opportunities for ensuring the openness of public authorities. I think it's a very interesting topic and a very important topic. My name is Ilham Abdullayev. I'm a chairman of the committee for the innovation development of IT technologies and IT policy of the legislative chamber of the. I'm going to be a moderator this session. Besides, here you can see on the stage Mr. Stambekov Nazimbek, Chief of Department of the Ministry of Justice, Umida Tukhtasheva, a Deputy Chief for the Counter-Corruption Agency, Shahnaza Sagatova, Advisor to the Ministry of Justice. Talking about the topic of our meeting and discussion, I would like to note that the openness of the matter is one of the most important issue to provide a democracy, and also it's affecting effectiveness of the public authorities, and it's also important that it is related to the issues of the trust, a matter of the trust from the citizens to the public officials' activities. In this regard, to assess all of the experiences we have in the Republic of Uzbekistan, we can talk that the Republic achieved success, great success in this area. We have a specialized legislation that was accepted about openness activity of the public and that's regulate activity in the area of public authorities and activities. And also we have a practical mechanism of institutional mechanisms, that's implemented during the last 4 years in the public authorities organization. And so it's remove barriers between citizens and public entities. And it's provide glassness and openness in our work, and it also to provide reporting duties, openness and transparency is one of this is part of the single process. The topic of our discussion is the openness of public authorities and the digital environment. So the time is flows, technology is changing, we get new opportunities, and we have new information communicational technologies, but it also demands and requirements from people is changing how you should provide the transparency. So today, even looking on our parliament, I can tell you that we conduct open sessions in the parliament that we put through the Facebook on the main TV channel, so nobody would be surprised to see this. So it's everywhere, it's implemented. When we also see the court proceedings that are fully integrated in the distance remote participation technology and the electronic evidences. So all of those things we actually see nowadays. Topics for our discussion, as I said, digital opportunities for ensuring the openness of the public authorities. The topics that we requested our distinguished speakers, it is covering a little bit more, but we mainly going to talk about informatizations of the public authorities and to provide the transparency, to provide the openness for the authorities. I'm going to present one by one. I'm going to provide a floor to each of the speakers. As a format, I would like to remind each speaker that each speech should not exceed 15 minutes. If you're not going to accomplish your speech 1 minute before the 15 minutes time slot, I'm going to remind you that you're coming to the deadline, to the time limit. And for the first report, I'm going to provide the floor to Mr. June Hanan, who is International Principal Digital Advisor, UK Government Digital Service. So her report on helping governments do digital better. So floor is yours, June.
June Hanan.
June Hanan, please, floor is yours.
So sorry. Thank you very much for your time this morning. I'm just going to share my screen with you all and quickly go through some slides for talking about from the Government Digital Service. So thank you for your time. I'm Jude Hannon from the international team in the Government Digital Service. It's a team of multidisciplinary experts to help government do digital better. Our work uses and shares the UK experience so we can help governments on their digital transformation journey and help create that trusted, transparent government services online, which is in keeping with today's forum. And I'm going to speak more about the things we do, the things that we apply, and how it creates that trust and accountability. A little bit about Government Digital Service. The Government Digital Service sits at the centre of the UK government and is part of the Cabinet Office. It leads the UK government's digital data and technology function. It has around about 700 staff and digital data technology experts who work, as I said, in those multidisciplinary teams. Our vision is to make government simpler, clearer, faster for users. And when we talk about users, we are talking about citizens, businesses and civil servants. We want to provide services that are easy to discover, to use, and by doing that, make government open and accountable. We want to help government communicate with authority and trust, make digital and user-centered publishing easy, and make government content easy to reuse and build on. Our services are published on gov.uk, and what you see if you go online was actually created back in 2011 when the team was given a mandate to rethink how government used the internet to better interact with citizens and deliver that more efficient, transparent public services online. In less than it's that single website for UK government holding all of those content and services. But it's so much more than just a technology project. It's about how we rethink and transform how government works and interacts with our users. And this is where the relationship between citizens and the state happens. So we've shaped gov.uk by life events. And the reason is that the user may interact at only certain points throughout their lifetimes, like buying a house, health, education, elections, and the justice system. And those life events are the of gov.uk. But more importantly, gov.uk has not only does it help gov.uk access the they need from government, and how it serves millions of users every day. Lots of feedback. Is everything okay? Okay. It provides incredibly valuable insights about what people need and how government can better serve those needs. So digital government, really from our perspective, is really about the core principles of good governance. It's not about the shiny tech. It's about getting the basics right with regards to how governments establish their relationship with citizens and how they set themselves up to do this online. And this is what my international team works with governments on. And we're using the UK experience. We do this in 5 elements, which is, as I said before, we start about with user needs. So a user could be, or user need could be a citizen's need, like as I said, buying a house, or the need of a civil servant running a service out of a department. But this is the most important transformational lens that the UK has applied, which is that putting user first. It's the heart of everything that the government digital service does, and it's critical to transforming that relationship between citizen and state. Part of this is our design standards or design principles that underlie our work. I'm not going to go through all of them. It's all online if you want to see it, but maybe the crucial ones, as I said, start with user needs. We've talked about this. Number 2 is do less. Doesn't mean do less work. It means keep it simple so that the services that are provided are accessible to everybody. Number 5 is iterate. So we don't believe in final products. We believe things are continuously improved through user research. And that's a super strong part of our work at GDS, Government Digital Service, and keeping that feedback loop going so we create that engagement and trust with our users. Number 9 is about being consistent but not uniform. A user journey doesn't have to be uniform to make it successful. And a user doesn't need to know who is providing the service. What they want to do is just get that service. So if you're hiring someone, for example, in the UK, you'd connect with 3 different departments: the Department for Work and Pensions, the Tax Department, and the police for potentially a criminal check. A person who's hiring someone doesn't need to know that and shouldn't really need to know that. They should just want access to the service they need. And number 10, which is really relationship about this forum as a whole, is about making things open. Our code is available and open on GitHub. which is countries can use it, but we don't recommend that they lift and shift it because of the country context. But we try and create things as open as possible. Again, as I said, we'll make things in the open. So we have open source, open data, open standards, open communities, open markets, and also an open culture. So part of this is our service manual, and this helps us design high quality services. And it's a help to design for departments to get their services to meet a standard. And that standard creates that consistency of openness and transparency. It provides guidance on how you choose technology, explains how you can measure success, and gives advice on making that transparency accountable service. It's a part of that openness that we look for. Making sure that those standards are applied, we have an assurance process. So things are documented clearly so everyone knows what they need to deliver and how they should deliver it. And doing an assessment and assurance process early on means we can add value to the end and the outcomes that support those services. So those standards, when they launched, are ready to go and are ensured that they are accessible. And it encourages that relationship with government between the state and its citizens. We also have common components. Common components are things that try and address common issues across government. So we have a common component which looks at verification of data, a notification component which notifies bulk users, and we have GovPay, which is a component that supports transactions where a services needs to be paid for. It means when we create the digital components, we are solving the common problems that we make things run more easily and quickly. And it minimizes supplier lockline, and it maximizes the impact of operational processes. 3, we're shaping the market. Core to creating transparency. This is core to creating transparency around the procurement of services. Back in 2009, we knew that digital spend was costing the UK government £16 billion, which is at that time converted to 1% of the UK economy. What we did to address that was to create a series of technology spend controls. And in the beginning, everything that a department spent on technology had to come to government digital service. Now it has a threshold of 100K. If that department had a large contract with a supplier and they wanted to extend it, a request would have to be submitted to the spend controls team. And we effected that cultural change by saying no and controlling how that money was spent. But you can't always just say no, though. You need to offer a solution. And part of our solution was the digital marketplace, which is a series of online frameworks that help departments buy government-wide products and services from the private sector to create a more consistent, cohesive, and a coherent way of getting suppliers. It helps us keep track of spending, creates opportunities for smaller companies, and provides transparency not only for the government, but also for the public about what companies are doing. When you sign up as a supplier, you sign up to common terms and conditions. The procurement takes only little as between 5 to 6 weeks, but it also makes it easier to publish and access high quality linked data about how procurements are planned and delivered, how the contracts are implemented, who owns the companies, and how the governments are working with them. It's that openness and transparency that we're looking at. Data is one of the last 2 elements that we're talking about today. In the UK, we look at how our focus is a key core element of our work is on data and making sure it's timely, meaningful, and actionable. And this is important because it underpins everything that we do. We have 3 key objectives around data. We enable the delivery of better services through better access to good data. We're looking to drive open and trusted ethical approaches to data. And we are supporting innovation, improving our data science capability so we can make better use of our data and increase and build on the quality of our services that we provide. The last point, and I'm quickly going through because I'm cognizant of time, is about building capability. So the last element that we've looked at from the UK government experience and how we make governments better and our work with them is building capability around digital data and technology roles. And we see this as a core way to move away from reliance on contractors and investing in the long-term development of digital government. Having long-term staff around digital data and technology roles helps us build trust in government as those people learn how government works. So that we have a capability framework which defines the roles around the digital data and technology profession and describes the skills we need to do a role. So government can see what skills are needed and what career paths are available, and it acts as a way to retain people in government as well as recruit people into government, thus making it more transparent about the skills that government needs. My final slide for today. So what worked for us is really what we call having a virtuous cycle, where we set standards, we've controlled the spend, but we've also advised and helped departments make the right technology choices. And using these elements, we believe government should be shaped by the services it provides, and those services should be shaped around what a user needs. This creates trust. Establishing trust and transparency online is absolutely essential if we are to unleash the potential of our digital economy. And again, just the last point, using elements I've discussed and the UK government experience at GDS International is how we work with government to do digital better, so that we can create that trusted, accountable, open services shaped on user needs. Thanks. I'll pass back.
Большое спасибо, Ханна Джуд. Действительно.
Thank you very much, Hannah Jude. It was very interesting to get familiarized with the UK experiences in the area of improvement of digital services, and I think that when we have a Q&A session, you'll have definitely questions. And the next is the role of digital government. And Lauri Mauska is our presenter, the member of Estonian Academy of Sciences of Estonia. Good morning. I would make some welcoming comments in Russian. Can you hear me? You can even speak a little bit lower. Yeah. There is some echo.
Can you take this echo down a little bit? Now it's better. Yes. So I will speak in English in the end, but I think that it is interesting maybe for Uzbekistan to get a view about this question also from Estonia, because we have this common Soviet background, right? Until 1991, our countries were the Soviet Union, and therefore it is perhaps easier to compare what has been undertaken and what not. Because the time is short, I will not even show my slides, but rather share with you my thoughts on this topic. So does it enable to create more openness for public administration, for the communication of the government with its citizens? I think undoubtedly, there is no doubt about that. Digital makes communication, easier. In Estonia, we file the tax declaration. You can do it with, depending on what you have to say there, with 15 minutes. But it concerns the other services as well. At the same time, we also have to. So if the question is, should the government push for further openness in terms of digital means, then I think the answer is undoubtedly yes. One should do that because it is necessary for competition in today's world. It is saving time. It is saving energy for other things that help us to create value or just to have fun. Things that life is supposed to be about. We should not run all the days between offices or something. Now, why I think one feature of using digital is, of course, that it leaves traces. And I think the fact that it leaves traces is actually something that in some contexts at least can diminish corruption, because you're not going to ask a bribe per email, or if documents are to be submitted online, then you don't have to go ask for a favor or something like this. I mean, of course, the experience of the world shows that digital makes all these phenomena like bribes and corruptive practices even more sophisticated. People still meet, they can still, handle out the deal behind the doors. But I think overall, when those mechanisms are in place, that when they are digital, for average officials, there will be less possibilities for corruption, because there is a trace, and you often actually don't see the person. I also think that digital will be a big equalizer, because ultimately, smartphones, internet, they make access to information globally much more available than it used to be. I'm currently 46 years old, and I think my generation, more than young people, for example, students today, who actually haven't almost seen anything else but the digital era, who grew up with internet, we remember the time before that. And for example, when I was student in the 1990s, then this divide or gap in even knowledge between, for example, my country and Western universities was much bigger, simply because we didn't have access to the same data. But digital and access to data is I think altogether much more equal. So if you are ignorant in today's world, it is partly your own fault, because you didn't access the data that was actually available to you. At the same time, I'm not representing directly government here, and I more academia, more university, and I therefore also want to say that while digital enables openness in principle, it can still be used for various purposes. Digital can also be used for gaining more control over citizens, or having simply so much more information about them. Now the question is, who in our time will have this information? Will it be the governments, or will it? We know that the digital companies already have that information, very detailed information about us as individuals, about our consumption patterns, and they are using it to make even more money, of course. Now, as far as government is concerned, only, let's say, technological openness or bringing something online doesn't automatically make a government open. So if the government does not, let's say, pursue democratic goals that would at the same time also respect, human rights and rule of law, things like that, then it is possible that, online or digital can also enhance totalitarian practices. So in some ways, digital is a form. The substance has to be given by each country themselves, by the decision what kind of country do we want to be. Digital enables to make some procedures more efficient, more accessible, but it doesn't tell you the answer. What kind of values does our society have? What kind of state do we want to be? Once again, we have examples already in today's world where, very advanced technologies can also facilitate, surveillance society, loss of privacy, when basically, not only companies, but also government knows a lot about us. And yes, I know people say that if I don't do anything wrong, what's so bad about it? If they know all these things about me, and you can ask that, and this is one answer, but it's also a fundamental question. How much privacy do we still want to maintain in the end of the day? So that do we also are we also scared of these kind of science fiction like aspects of George Orwell's Utopia 1984, when technologies enable the big brother to watch us all the time. So in terms of human rights, concerning with digital developments and openness that states opt for or maybe sometimes don't opt for so much, then a central question, of course, is that what happens with the data and data protection. So in the European Union has been a leader in that regard with its data protection directive, and it has been very interesting to follow. I'm not an expert in details of this, but how practices of companies and institutions have changed after this data protection directive was adopted. People are more careful because they are legally mandated to be more careful with other people's data. You get less spam by other institutions simply because someone decided to take your email and put some mailing list. No, you need to, as individual, you will have to approve in order to be there. And I understand that currently many regions are trying to or are seeing this as a kind of model, but it takes political will, of course, to change this kind of to really also implement this kind of regulation. Well, in Estonia we have some specific aspects of how the state works that maybe go even a step beyond what is usual in advanced countries. So, for example, we have generally something called e-government, but also the possibility to vote at elections online, and we actively use this opportunity. It is used in some other places in the world as well, but I think Estonia is considered one of the pioneers in that regard. And it hasn't gone without debate. And even some fractions in Estonian democracy are also questioning this. Is it safe? Is it always, will somebody know how I voted? How do we know for sure that no votes were added? These kind of questions are asked, but already for years we are practicing it, and what in my childhood used to be the election day when the state decorated the election stations, this is nowadays more and more an online day. People do it with a mouse click, and it is an experiment because most Western countries still haven't opted for it. It could be that it is easier to implement in Estonia because we are only a nation of 1.3 million individuals, and these kind of, big things maybe in some ways, smaller ships, they are easier to turn, to navigate. It's probably having the same kind of system for a nation of, let's say, 60 or 80 million, or even the country of the size of Uzbekistan would already be slightly harder because of the size. We also have something called e-residency, because our electronic, this e-government is so relatively advanced. Then actually people from outside the European Union can, using our systems, can found an EU company. Of course, Estonia makes a little bit money from that as well. And the other thing we are currently discussing is that safe? Does it have also problematic features? Everybody wants to sell their services, but does it enable to fund things that maybe shouldn't be funded? Things like that. In any case, it has been for me very interesting to follow this debate that, people who want to use those Estonia's advanced systems for selling a product in a way of public services to also people from outside the EU, they of course praise this e-residency, but some of the security people they are a little bit more hesitant, saying that it also has its own downsides, and it's very important to also check the background of people who end up using these systems. But then the question is, are such checks in place or not? So my final word is that I think that the current COVID crisis, of course, gives a further boost to digitalization. So in this sense, I want to congratulate the organizers of this year's conference that you have chosen this topic very, very well. We literally cannot meet, at least all of us. So we are forced to think about how do we make these kinds of systems even better and make our governments more open, but in a way that will really not be like a big brother is open to have all our information, but really having the final aim, final goal in front of our eyes, which is the well-being of our citizens, of all individuals. I thank you very much for your attention, and I'm looking forward to discussions afterwards.
Большое спасибо за ваше выступление, господин Lau.
Thank you very much, Mr. Laurinowski, and special thanks for keeping time very precisely. And you expressed very valuable ideas, and I think that we all agree that the openness standards should be filled with certain content, and they should be aimed at the provision of democratic rights and protection and freedoms and liberties of citizens in this area. The next speaker is Mark Ober, and his presentation is on Law Tech with Trust, how can technology enhance public trust in government. So the floor is yours, Mr. Mark Ober. So our section is called digital capability. It would be very, very weird if everything would go smoothly, that, and now we lost the connection, and it's quite natural because it's digital era. So the organizers are abusing this thing. So I can talk very extensively.
That's wonderful news. Good. With the power of technology,
Мы вас слышим,
fails
пожалуйста.
to let us down. And we're here today to talk about how legal technology might enhance confidence in the government, enhance public trust in the government. And this is something I've been working on for many, many years. I was part of the team that built the first virtual court in the DIFC, something which has become so popular in the last couple of years, but at the time really was a world first. And I think it's wonderful to be here virtually in Tashkent. I wish I was there with you in the room. One of the most exciting, Uzbekistan, one of the most exciting economies, alongside Kazakhstan in what is one of the most exciting regions in the world in Central Asia. So I also started the Courts of the Future Forum, which I'm just testing to make sure you can still hear me.
Мы слышим вас хорошо.
Yes, we can hear you well, thank you.
Spasiba. So I also created the Courts of the Future Forum. And the idea there was to say courts today are struggling to serve people with today's problems. But what happens when companies are formed in the Kingdom of Asgardia, which is a bank of computer processors in space? What happens when assets don't exist within any court's jurisdiction? They exist on 2,000 servers across 50 countries. How can a court enforce its order over 50 countries? Almost impossible. So where will the world go? And I work with the World Economic Forum as part of their justice team and their rule of law team to look at how we're going to deal with those issues. I became president of the International Association for Court Administration, which sets standards for courts around the world and helps them to shape a journey towards a digital justice system. And I co-founded the Metis Institute, which advises governments and judiciaries on development. So I'm really, really keen on how technology can improve the lot of the citizen. But I'm here today in my capacity of chairman of the Astana International Financial Centre's Law Tech Advisory Council. And this is a really revolutionary and exciting body. There are only 3 financial centres in the world that are deeply looking at law tech at this nascent early stage of legal technology. And one is in London, the other in Singapore, and the third in Kazakhstan. So I'll acknowledge all of my colleagues from Kazakhstan and the AIFC. So what we're going to talk about today is, what is public trust? Why is it important? Can law tech help? And if so, how? And I'm hoping I can now share my screen. Let's try this.
Мы видим.
Yes, we can see it.
In Law Tech We Trust, how technology can enhance public trust and confidence. So what's public trust? Public trust as a concept is something that Warwick University and the International Framework for Court Excellence has looked at. They've asked people, if you were to have trust in the government, trust in the police, trust in the justice system, what does that look like? What do you need? And this was the feedback. First of all, we need to access it. Now, it sounds simple, but in a study done by the Hague Institute for Innovation of Law, of 40,000 people around the world, 95% of people said that if they had a serious legal issue, they wouldn't use the courts. 95% of people said if they had a serious legal issue, they wouldn't use the courts. 84% of people said they wouldn't use a lawyer. So in today's world, people don't feel they have access. When they were asked why, they said, because the courts aren't for us. The courts are for rich people. The courts are for powerful people, but they're not for us. And that means the courts are serving 5% of the population. Question, does that mean people have faith in the courts? The next one is they must be responsive. There's no point calling the police and they arrive in a week. The government has to be responsive, as we heard earlier, they're responsive to people's needs, and it has to be reliable. You have to be able to depend on it. You have to have faith in it. And it has to be transparent. They say that sunlight is the best disinfectant, a transparent system, one where people can see how it works, for good or bad, is something that the public wants in order to have faith in the system. And it has to be efficient. Justice delayed is justice denied. It has to be efficient. And people have to be satisfied with it. You know, this concept of user experience, user satisfaction, customer satisfaction is something that most courts have never even contemplated. And I'll talk in a little while about why satisfaction is so critical from a country perspective. But when we built the DIFC courts, we became the first court in the world accredited to the same service standards as airlines and hotels. And in Dubai, the airlines and hotels are very good. The first court in the UAE to be awarded 5 stars for customer service. Customer service, customer satisfaction, critical part of building public trust and confidence. And approachability. Now, approachability is 2 parts. One is when you turn up at an institution of government, it shouldn't look like a prison, you know, unless you're going to prison. It should look like an accessible and approachable environment. But actually what people mean by approachability is this. I want to approach my government when I want, how I want, on my phone or my iPad. Approachability. And then accountability. I want to know that if something goes wrong, it will be aired in public, it will be dealt with in public, that the system has KPIs, that they will publish annual reports, that I as a citizen paying for this service want to know that the people involved are accountable. It must be fair, and there must be some sense of empathy or mercy or justice. So that's what the public wants, to trust the system. That's what it wants from the system. So why is public trust important? Well, you're going to say it's important because we want citizens to be happy with the government. We want them to have faith in the institution. And that's absolutely right. In many countries, they're paying for it through their taxes. But beyond that, public trust becomes really important in areas such as reputation. A big study in the US showed that when businesses were asked about investment abroad, they asked companies that have been through the legal process in a foreign country, and they said, what do you think of the country? And it was interesting that what they found was people's perception of a nation has more to do with how they're treated by the nation, especially when things go wrong, than the outcome. That is, for the court, the process of the court is more important than the outcome. Did people feel trust? Did they feel that it was an environment that they could trust? So the reputation of a nation, particularly from people abroad, is based on how they're treated, how they feel about the nation. And that leads to investor confidence. I'm talking here about sustainable investor confidence, confidence that creates jobs, creates opportunity, shares knowledge, shares technology. True sustainable investability. That requires trust in the institutions that exist. But if you get it right, the impact is 50 basis points of incremental GDP per year of economic return. Now for Uzbekistan, that is $300 million simply by boosting investor confidence. The cost of credit goes down. At the moment, the base rate in Uzbekistan, 14%. How can an Uzbek company compete on the international stage when a Swiss company is borrowing money at 25 basis points and an Uzbek company is borrowing money at 1,400 basis points? How do you reduce that cost of credit? Solid, trusted institutions that banks feel comfortable lending through. Average impact, 200 basis points of reduced cost of credit. Societies are more lawful when they trust the system. You can't police a society using police and the army exclusively. Citizens have to want to comply with the law. And to do that, they have to have faith in it. And if you get it right, the cost of the criminal justice system comes down because people comply with it. You don't need as many police. You don't need the army to enforce. You don't need a sort of state behind the state to protect the lawfulness of the citizenry. So how can it help? Well, LawTech, as we know, is the nascent stage. It's sort of where fintech was 15 years ago. It's at that very early stage of using technology to help people with what they want. When the Hague Institute asked 40,000 people, what do you want from your justice system? Do you think that they said, I want a bigger fight. I want to spend more money with lawyers. I want to have judges with more technology in the court. Not at all. What they said was, tell me, have I got a good reason to be cross? Have I got a case? Have I, has the law on my side? And will you help me settle? And of course, technology is wonderful at no and low cost legal advice. The picture there is of a robot that exists in the Beijing courts. And in China now, you can send your legal question by WeChat, which is like WhatsApp, and the court will give you some legal advice. And that's what the citizen wants. And that's what technology can deliver in a way better than any lawyer can. Because a lawyer doesn't want to be answering a question about whether the neighbor's fence is on the right line. That's an expensive thing, but technology can help. And if you do have an issue, technology can help you settle. And there's lots of good technology platforms now which help people resolve their problems, not fight them. And even if we look in the context of digital justice, the process of justice, the inefficiency of moving paper around, has been transformed using technology. The ability to live stream court hearings to YouTube, to have 99% accurate transcripts going immediately up online, for people around the world to watch court cases as they go on, that publication of justice is something that technology has improved. The ability to analyze whether the court's doing a good job, whether centrally as they do in Kazakhstan, in China and elsewhere, or at a court level, which judges are taking too long to write their judgments, which judges have better settlement rates than others, which court administrators are actually moving things forward and which are doing a terrible job. The analytics of the system are now available. When I ran a court, I had a dashboard on my computer and it told me how we were performing against every KPI that we had published to the community saying this is what we will deliver. I had a dashboard telling me how we were doing. But also, computers are now better accurate, more accurate than humans at predicting the outcome of cases. Computers can predict the outcome of cases better than lawyers. So if you know the outcome, the chances of you ending up in court are much lower. Settlement becomes easier with analytics. And lastly, and this is contentious, but computers are now delivering better decisions than human judges. Now, not in every area, but the research that's come out of Harvard and Yale and Stanford and MIT and a group of universities is, for certain issues, AI is producing more accurate results, more accurate decisions than human judges. How long before technology can produce judgments? And would that help communities in Brazil with 100 million cases backlogged, or in India with 29.2 million cases backlogged? Would that help, at least at first instance, to give people some justice? I think so. So let's finish up by asking ourselves, what can law tech actually do? Of all of these components that people said were critical to building faith in society, to enhancing the economy, to promoting inward investment, to making society more lawful, we know that computers can offer better access. They can give people access in a better way than the traditional court system. We know that computers are more responsive. They don't go on holiday. 24 hours a day, 7 days a week, 365 days a year, they can respond to what the public's asking. We know they're reliable. They're very reliable, in fact, much more reliable than moving pieces of paper between desks in courts or sending couriers. We know they enhance transparency by allowing for documentation to be published and available and courts to be available. We know they improve efficiency of court.
Last minute, Mark, be over.
Yes, no problem. Well, I finished now, but we know they improve satisfaction because users can access justice as they wish. We know that by offering technology through mobile phones, they make courts more approachable. And by having KPIs live streamed real time on how courts are performing, they make justice more accountable. And what does that leave us with? That leaves us with fairness, empathy, and sympathy. And isn't that what we want the people in our courts to be focused on? There's a saying which is process and procedure is the domain of those without the wit or intelligence to do their job properly. So let us give process and procedure to technology. It can do it better. We know it can do it better. And let us leave humans to do what we do best. Fairness, mercy, equity, empathy and sympathy. And I think that is how one can build real public trust in the system. Thank you very much.
Большое спасибо, господин.
Thank you very much. It is a very interesting presentation about the experience of the transnational experience and the issues that you talk about the public trust. It's very important, extremely important, and I think we're going to talk more about this. And our next speaker is the law faculty of the Estonian University is the Tartu Faculty of Law, the human rights in the digitalized world, a real challenge or the opportunity. So, Madam Marilyn Key-Waring, it is floor is yours. Thank you. Thank you. I'm gonna continue. I'm going to continue in English. I just feel much more comfortable speaking in English than in Russian. Sorry.
Hello, everybody, and many thanks for inviting me to this very interesting and timely forum. It is an honor to be here, to also see some old friends and new colleagues. I am actually associate professor of international law and human rights at the University of Tartu. So my main job is to teach next generation human rights lawyers or lawyers generally, good lawyers, hopefully, who can operate also at the international level and who know well about the protection of human rights. I have also advised some governmental institutions on various topics of human rights. I also contribute to work of the OSCE in one of its advisory panels. But here I am in my own capacity and not representing OSCE, but I'm in a capacity of a university scholar. So my presentation is going to kind of build on to what Professor Malkso already presented. I will approach it from a slightly different angle and with a more focus on human rights and not maybe that much on Estonian experience and comparing it to Uzbekistan. Because the field of human rights is also something which is important for all states, and we can talk about that more generally also in the digital world. And of course, there is this kind of academic side to this discussion. Human rights, discussion of human rights and research also in the digital world, and how we conceptualize the situation in the digital world is something we need to perhaps even constantly think about, because things are developing very fast, technology is changing, and this reasoning, even this kind of forum today is perhaps we have to admit that we are kind of lagging behind a bit when we are trying to rationalize over what is happening in the digital world, how we build trust, how we contribute to democracy, how we protect human rights as well, and avoid harm happening through the system and technology. So theory and concepts are important, but we might be a bit behind, but that does not diminish the importance of talking about that. But also the practice is important. The practice, how and what exactly needs to be done. Because we're also talking about technology, and technology itself may be a solution to a problem, what we may or may not have. So we need to think of also very innovatively how we use the technology in the best way to protect human rights, build trust, have good governance, promote business, and etc. So technology may be something which inhibits human rights, but also maybe it gives some more opportunities. So I would perhaps start this human rights part with the emphasis on what actually High Commissioner of Human Rights has pointed out, UN High Commissioner for Human Rights has pointed out in 2019. And she very powerfully said that at its best, the digital revolution will empower, connect, inform, and save lives. And at its worst, it will disempower, disconnect, misinform, and cost lives. Well, it's true, as pointed out by High Commissioner, that today we can use technology, for example, via encrypted communications, satellite imagery, and data streams to directly defend and promote human rights. This technology is available for us. We can even use artificial intelligence to predict and head off human rights violations. For example, used in important fight against terrorism and all sorts of extremism, also monitoring certain groups and individuals that can cause harm also in very real life, not just in digital world. Well, there are, of course, problematic aspects to that as well. I come to it later. However, even when we talk about protection of the most basic right, the right to life, but also right to physical integrity and personal security, we also have challenges. We also have challenges. And one may be reminded that in one of the most deadly cases, social media posts, for example, targeted the Rohingya community in Myanmar in the run-up to the mass killings and rapes in 2017. Human rights investigators found in that case that, for example, Facebook and its algorithmically driven news feed had helped spread hate speech and incitement to violence. And well, Facebook was not probably doing it intentionally, but the system itself kind of helped. And bad people were using the online platform. And this is not an only example, for example. And in that respect, perhaps it has also been pointed out that responsibility in a way lies in many different, with many different actors or agencies, like individuals themselves who spread hate speech, governments who have to do something, and also online platforms. And maybe many of you already know that landmark case, which was, for example, in the European Court of Human Rights, Delphi versus Estonia. This is my one connection to Estonia, reference to Estonia, landmark case in the European Court of Human Rights, where the Delphi is an online platform, and it did not remove bad comments or hate speech comments from its portal, and did not do it quick enough. So it was found that it was liable. It was found liable in Estonian courts, and Delphi took that case to the European Court of Human Rights and lost that. So the European Court of Human Rights from that on also has made it very clear that online platforms themselves are responsible for the content which is posted there. But coming back to the right to life, regarding right to life, technology can be abused to commit most horrific crimes. Even in some cases, we can say it has led to genocide or ethnic cleansing. One, of course, can question whether these things would have happened anyway, but to certain respects, the technology has been abused to spread the information or hatred, perhaps in a more rapid way than it has ever been possible. But loss of lives has not happened only at the group level. For example, targeting certain specific communities, or minority communities, migrant communities, but also at the very individual level. Vulnerable groups like children, women, if we think about pedophile rings and human trafficking, but also when we think of online bullying has occasionally amounted to pushing people to commit suicide and self-harming. And recently, for example, in Estonia, a police operation took place which cracked down an online sale of drugs. The criminal group was using a social media platform where they passed to each other or possible customers, I would call them encrypted messages. They use their own language to sell drugs. And Estonia has a zero tolerance to drugs, and the abuse of drugs is a quite of a problem. So that was a positive kind of outcome from a state activity in that era. However, not just right to life, but all generations of human rights, like civil and political rights and socio-economic and cultural rights, and also, if you wish, third generation rights, like such as right to development and clean environment, have been affected both in a positive and negative way by development of digital world. In the sense that there have been real challenges to some of these rights, but also real opportunities. And using Shapiro's comments from the frontline defenders that technology is a weapon to be defended against, but it is also a weapon for us to speak truth to power. So one of these perhaps most prominent civil and political rights which have been affected, and Lauri Melks also has been referring to that as well to a certain extent, is right to privacy and right to or freedom of speech. And both these rights have had good and bad times in the internet, in the digital world. Freedom of expression, we cannot imagine anymore our lives without the digital phones. We use internet daily, at least in many parts of the world. This is another issue which comes up with the digitalization and human rights, because it also can create a certain inequality globally, regionally, where we are talking about access to technology and use of technology. So access of using technology. And if you think about that, freedom of expression is not only about talking or spreading your information, but it is also including the right to receive information. So putting restrictions on receiving parts may end up creating the mistrust, misinformation, but also inequalities regionally when we talk about digital capabilities. And right to privacy, of course, is another issue. Even if you think about in the theoretical terms, what exactly we are talking about. Is the in digital world a private sphere or public sphere? And I'm getting an echo again. So there are also these aspects, so that how much the state, for example, has to interfere when a person, him or herself, puts him or herself into position that it enters this public sphere, and all of a sudden he or she gets bullied or put in a position where there is harm. Also, it's a question of how much the state has to keep its hands off of this private sphere of where people are operating in the digital world. That concerns, again, the surveillance, data collection, how it's done, how it's practically done. Is it supervised, for example?
Excuse me, last minute.
Excuse me, this is the last minute.
Thank you very much. Yeah, I'm basically starting to sum up my talk anyway. So unfortunately, authoritarian governments have been using, for example, the technology also to censor, block or filter access to information, monitor online activities, and more effectively and efficiently control populations. And they did in pre-technology world. One could point out, for example, the research which was done actually at the Oxford University in Bonavera Institute of Human Rights, and I very much agree with their reasoning in that. They were commenting on UK white paper on online harm. It's a policy paper, and the point they put across was that the internet has revolutionized our ability to communicate and connect across historic, social, political, and geographic divides. This development bears great opportunities for the democratization, for example, of free expression and diversification of discourse, but has likewise broadened the potential for the impact of harm. And one of the main conclusions that the team did, and I agree very much with that any regulatory approach to online harms should be expressly founded on human rights law. Human rights law provides both a sustainable normative framework as well as crucial guidelines to assist regulatory decision-making, especially in balancing competing rights and interests in online sphere. Thus, the starting point has to be human rights, not other premises, for example, security or due care or whatever we may have in mind.
Госпожа Киоринг,
final points. It can be concluded that there is
Мне придется ограничить.
I have to limit your human rights in digital words, but you are abusing the time which will provided to you. So the last minute is yours.
Technology. There are bad or irresponsible people and governments who abuse technology at the detriment of human rights. Ideally, one supports the other. Human rights are essential for a democratic government, and also they cannot survive without democratic governance. If we want to have one, we should have another too. This is also important to what was pointed out by our moderator, the trust. You can only create trust in a digital world if your government has a good record in human rights protection. One thing is clear, that interaction between digitalized world and human rights need a global discussion like the one at the moment at hand, and possible global response to avoid pitfalls that will put human rights and democratic and open governance in jeopardy. Thank you very much, and I извиняюсь for abusing a little bit of time.
Большое спасибо, было очень интересно.
Thank you very much. It was really interesting. Our next presenter is Eliza Nevedomska, Senior Advisor of the European Bank for Reconstruction and Development. So the floor goes to Eliza Nevedomska.
I'm sorry, I'm going to speak English, if that's okay. And thank you so much for inviting the bank to join the session. As for us, the question of open government is one of the critical topics we are looking at over the last couple of years. At the EBRD, I'm working for Legal Transition Program, a unit that is supporting development of reform projects, implementing new policies, and working with the government to make the regulatory framework serving the business and the citizens. I am a public procurement counsel. So for this session, I have picked up for you a story which is about open government, open data, and public procurement. I hope that you have heard about EBRD previously, but we are this unusual development bank, which is mainly focused on supporting private sector, supporting economic operators, and making the economy more modern, digital, and green. We have been looking at that question of how to make public procurement trusted by the business, trusted by the citizens, and we had to ask ourselves what we really want from public procurement policies. And we ended up with the conclusion that we actually do care about the classic values of the procurement policy, which are around value for money, efficiency, transparency, but we also have to be clear that a lot is dependent on fair treatment, participation, and public confidence. And this is something what I wanted to focus this presentation on, because for public procurement policies to work, we have to have the policies that deliver for the government, that deliver for business, and that deliver for civil society. And while we all want to see quality public services as citizens, we also have to be able to trust the government approach to how to award public contracts, how to deliver public contracts, and how to make public infrastructure and public services work. And this is the problem that is unresolved by public procurement policies for a long while, because when you look at academic question how people behave dealing with money and making purchases, public procurement is a high risk area, because when we are looking to buy something for ourselves and we spend our own money, we do much better care than we are taking when we are spending someone else's money or we are buying for someone else. And you see that public procurement is here at this bottom range, where we have the case where people who don't own the money are buying for other people things that they desperately need. And looking at how the public procurement is regulated, we have long been promoting at the bank that actually we don't put the efficiency and value for money needs on one side and transparency on another. We do believe that digital technology is allowing the governments to get as much value for money as they want and provide a full transparency of the process. And it's important to point out that majority of the government spending is actually at the bottom of this pyramid that I have put on the screen. So the high value procurement, big projects, visible infrastructure, they are the top of the iceberg. But the government money is actually spent a lot on goods, services, and works which are underpinning public services. we don't know what's the proportion for Uzbekistan, but we clearly can share with you that when we looked at Ukraine for the first time, Ukraine was spending 60% of the state budget below the threshold of public procurement law. And this is not the thing that we would like to recommend to the governments. So how to deal with this pyramid? Because when we look at the procurement policy, it's clear that it's easy to over-regulate. So if we would try to apply the same rules as we use for expensive projects to daily purchases, this policy will be perhaps the most hated policy in the government. But if we look at the values brought forward by the open government approach, we can see that we can engage through the technology, engage through open data, and engage through transparency with the market and make it work for all. And what we have realized working with the governments on rethinking public procurement, it is that civic monitoring can drive change in the government and can make public procurement policy work better. This is happening when the government does invest in digital procurement, and this digital procurement has to serve the users. So we have to have systems that are easy to use and allow everyone to do a good job. And finally, open government means that market access in public procurement is made available for both the big businesses and small. And we approach their needs appropriately when we design digital tools, when we talk about how government is trusted and how business perceives the fairness of the public procurement awards. So looking at the principle of open government, I would like to pinpoint two ideas. The first one is that while it may be counterintuitive, it is proven by the academic research that more transparency is actually bringing more competition to the market and more openness of the government to digital solutions working for low value purchases, for high value purchases. They bring us a better quality public services. And what we wanted to bring here as an example is the work that we do around digitalizing public procurement, while at the same time we try to make sure that government is working with data. And this is my favorite picture ever, and this is the reason why I'm sharing it with you, because when you look at the standard electronic system, doesn't matter what's the objective of the system. The data inside the system looks like this bunch of Legos spilled on the floor. Everywhere, everything is here. Yes, we have this information, but do we know where and how to access it? And this is precisely what policies on open data do. They allow us to make the information accessible to all, because from this heap on the carpet, it is becoming these tower blocks that we have when the data is being visually presented. So our favorite topic is to work with open data concepts to make sure that every public procurement system generates as a standard open data. And there is a bonus for the government here. Not only data is being made accessible, but also this makes it easier for the government to integrate public procurement systems with other government systems. So this is a brownie points for the governments who start designing digital public procurement tools, having open data in mind. And finally, how this is impacting enforcement of the policy. Where everything is super transparent, monitoring can be automated. Audit of procurement can be automated. We can have a much better overview and supervision of how the public money is spent from the government perspective in the first place. And on the business side, we have a more willingness to engage in public procurement and participate in public tenders, because they can trust that the system that is so transparent will bring them fairness of treatment from the government awarding the contracts. And finally, where we have no case for the business to look more closely at how the money is spent, the open data that is being made accessible from electronic procurement system allows citizens to provide the feedback. And this final point of the open data in public procurement concept, which says that, okay, open government is about transparency, so use open data, is about accountability. Yes, try to digitalize compliance requirements for this policy to make it easy to use for everyone. And finally, the engagement with the stakeholders. And in this case, procurement is pretty obvious because it does engage with the business community and does engage with citizens who are users of the public services. And if they see that the public service is of quality that is substandard, they can provide feedback and they can improve the performance of the business delivering this service for the government, but also the performance of this service for the government and us all as a total of users. So what is the story behind public procurement and open data and the benefits from the adopting the policies which are promoting designing digital tools with open data by default? The story is very simple. When we have no data, the government is blind. And we are all exposed to abuse of the law. We are all exposed to corruption risk. We are all exposed to waste. When we have some data, we can perhaps start looking at how procedures are working, whether they are good procedures. Are they delivering the objective for which the government put them in place? But this is not allowing us to bring the benefits of the knowledge about how the market works to the market users. So to be able to digitalize services, to be able to make compliance with public procurement laws straightforward, and to be able to manage the market through data, we have to have a complete reliable data delivered by the electronic tools for procurement. And this is precisely a story of the countries that have invested into open government in public procurement. I have brought here Ukraine because it's my favorite case of working with digitalization of public procurement. And over the years, Ukraine moved from procurement being perceived as a very corrupt area and very dysfunctional and inefficient, has moved in the eyes of the business and in the eyes of citizens to the place where they started to trust that this policy works because it's fully digital. And what we have seen on the market as a market impact? Well, in 2015, there was 14,000 companies bidding for public contracts in Ukraine. Guess how many is today? We have almost 180,000 businesses participating in Ukrainian public procurement market. And they do it because participation is digital, the procedures are relatively straightforward, and they can trust that their proposal will be fairly evaluated because the evaluation is done online in real time, which is limiting the scope for manipulation. So yes, it is my favorite story to share with you because we can see that open data can help us to make procurement better for all.
Last minute.
Much.
Еще минута, госпожа Неведомская.
Madam Nevedomska, you have 1 minute left.
That's great. So let me come back the summary for the stakeholders. What we would like to see happening in public procurement as a result of having digital tools and digital data, it is a change between enforcement of this policy to engagement to make this policy continuously improved and working for the market development. And what it means for the government, it means basically this requested perspective of being able to understand whether the policy works, to look at how targets are achieved and whether what the government has intended through this policy, it is actually delivered. And for the business perspective, the engagement means that market access should be the way forward to make sure that even the small business has a reserved place on the government contracts. And this is a very valuable experience for the small businesses because they learn to compete, they learn to expand and improve their businesses, and they learn to grow instead of relying on the government handouts towards the micro enterprises. And in terms of how we look at it as a users, I totally share this belief that people want to know how the money is spent, especially when this money is coming from their taxes, and they are the daily users of the public services provided by the government. So if you would allow me, I'm very happy to say that the latest project that I work on, it's actually a project for Uzbekistan, which is related to working with the Ministry of Finance on incorporating new approach to the digital public procurement tools to make them speak in open data. So I hope I will be able to share this super exciting experience next year when the new policy and the new system will be already operational. Thank you so much.
Thank you very much, Madam Nevidomsky. The speaker is Khurram Farooq, the senior expert of the World Bank, and his report of the open technology. Mr. Khurram Farooq, floor is yours. Government and technology.
Господин Фарух, мы вас не слышим.
We cannot hear you, Mr. Farooq. We can see presentation.
Hope you can see the presentation. So I will quickly go through the. My previous speakers actually have spoken wonderfully, and they have covered much of the messages. I will echo the same messages from a different perspective. But before I start my presentation, I want to congratulate the government. This is really a very relevant and timely topic, and in times of COVID, when governments around the world are under pressure, where debt has risen to around $12 trillion, and citizen expectations are rising from the government. This is really the topic that will enhance efficiency and trust in the government. So I will talk a little bit about what is the state of open government around the world and why we need open government, and I will echo the same messages. And I will also spend some time in sharing some other stories from the field, and then maybe some correlation between open data and country incomes and implementation of open government. What are the key constituents of implementing open government? So governments around the world are embracing this wave of open government. More than 100 governments have partnered with the Open Government Partnership, And we see a trend in, for example, governments are issuing legislation, action plans, policies. You see on the screen the US government's Open Data Act that makes it a requirement that federal agencies will publish their information online as open data using standardized machine-readable data formats with their own metadata included in the data catalog. Similarly, UK government, and Jude has mentioned her own experiences from the UK government, Mexican government, Taiwan government is ranking number 1 actually. They have shared 40,000 data sets on the portal, which is accessible, which is open to everybody. I think UK government, as I remember correctly, they have issued 33,000 data sets which are open. And then there's a global report issued by the Open Government Partnership that gives the collective results. So this is a wave that is spreading. But why this wave is spreading? This is because the trust in the government overall is decreasing. It has dwindled over the last few years. If we see the Elderman's Trust Barometer, 57% of the citizens around the world, they don't trust their government. They say that government is working for the rich, for the very few people who have access to the government. So trust is fundamental because it's, what are the key constituents? So every key constituent of trust is supported and enhanced by open data, whether it's transparency and accountability, or it's about fundamental rights, it's inclusion. And open data also creates, there is another dimension of jobs. For example, if governments open their data to media, to civil society, to business, it is more likely that they will reduce corruption, it will be more transparent, government will be more under pressure, and the civil servants will be more accountable to deliver better outcomes. And citizens will also feel more engaged, and it will reduce discontent. And overall, it will improve trust in the government, which is very important for an effective government. Similarly, fundamental rights. Democracy is not about elections. It leads a lot of other things. The right to seek information is one of the fundamental rights. And similarly, right to seek justice, as some of my colleagues have mentioned in the previous presentation on fundamental rights. So sharing information of the government is a fundamental right. People should be allowed to see what is happening inside the government and participate in the government activities. Inclusion. Now, most of the government are facing very complex service delivery challenges. So it is, the government cannot do this it alone. It has to include people in its decision making to get the pulse of the people, to get the sentiments of the people and get feedback so that it can constantly modify and tweak their policies to align with the citizen expectations. So inclusion is open government are more inclusive, and they provide a platform for inclusion. Jobs, again, many governments have open data with a slightly another motivation. When you open up the data can be used by startups and small and medium enterprises, and they can reuse it and repurpose it to create value-added services. You might have seen weather apps, for example. Many startups have done weather apps which are using the government data on the weather. Similarly, property information and school information and information about train timings and flight timings. All this data, all these apps and the portals are used by the startups and the small and medium enterprises to create value-added services for the citizen, which helps in creating jobs. So there is a theory of change. Data leads to better lives. And World Bank has recently issued a World Development Report 2021. So the data sharing is actually it's a two-way street. Government and international organizations are creating reams and reams of data, which is being shared with the individuals, civil society, academia, and businesses. But the businesses and other individuals are also creating data. So if those data can be correlated, government can be very effective. And it creates greater accountability, it creates better policy making, service delivery, and it increases business opportunities, as I mentioned in my previous slide. So here is again some research done by the World Bank in its WDR 2021. If you look at this correlation, so you see the more high-income countries are generally more open. For example, if you look at the indicators on the left and see the scores, so the openness scores from 0 to 100, low-income countries on average have 38, and the high-income countries have high score of 66, and similarly low middle-income country and upper middle-income countries. Similarly, availability of machine-readable format. High-income countries are more, they have made their data available in a machine-readable format more than the low-income countries, and similarly available in non-proprietary format and download options available and open terms of use. These are some of the components of open data, and you can see on each and every component there is a positive correlation between openness and income levels in the country groupings. So I will be very brief. Some of the stories from the field. Eliza, my colleague from the European Bank, she shared the story of Ukraine. So this is one of the very compelling stories. What started as a civil society, there was a hackathon, and a small group of developers developed this software called Prozoro, which uses the government procurement data to see whether the government procurements are efficient in terms of price, and compare the prices with the market prices. After initial success of this prototype, this system was adopted by the government, and now this is one of the most compelling success stories of open government and open procurement and open contracting. The numbers that I got from 2019, there are 700,000 plus users. 74,000 concerns were raised by the citizens using this open data, and actually out of these concerns, 20,000 were found to be actual violations of procurements. So what is the result? The result is that government was able to reduce overall average price of its procurement from 3.5 to 5.8%. 82% of the private sector reported reduced corruption, 50% increase in new firms and SMEs, as Eliza also mentioned. And then they're getting more bids, there are more savings, more competitive bids, and reduced time to procurement. Similarly, in Lithuania, the judicial administration decided to improve its trust in the judicial system by opening the performance of the judiciary on its portal. So the performance of the judiciary, like number of cases by each court, the experience of each judge, and how many cases each judge deals with, and what is the budget of each court, and the time takes for a judge or for a court, average time to decide a case. So all the performance information is put on their portal, and using those analytics that my colleague Mark mentioned, there is better citizen engagement and more trust in the government. And it has also helped the judiciary actually to reform itself, that performance management system, the judiciary. When the data went out, they realized that there are some fundamental issues on the performance management, how they are monitoring the performance of the judiciary. So it's a two-way process. Not only citizens get trust and confidence, but also due to the feedback, that public authorities also have an opportunity to fine-tune their policies and their systems. Another example is from Brazil. Brazil has issued an open budget portal. All the spending at a very granular level is shown on the portal, which agencies are spending how much money, which territories are getting budget, how much spending is happening in which territories, on what procurement items, and so So 900,000 visitors on the site. Look at the interest that the public has shown on this data. There is a desire there is an expectation and a desire of the citizens to look at this data, and then data is updated on a daily basis, and then this site was awarded Best Practice Award from the United Nations Transparency Initiative Conference and European Meeting on Anti-Corruption 2009. So a lot of awards for this site. Similarly, another example is from Ohio State. They monitor transparency on 13 dimensions. And Ohio State in US government, they had a score of 51 in 2014. And then they realized that they need to do a better job of opening up their data on all these dimensions. And next year, within 1 year, they were able to get their score from 50 plus to 100, which is the perfect score, 100, full marks, by spending just less than $500,000, around $800,000 they spent on this portal. And then you can download the data on government spending. Citizen can search the data by agency, by recipient, by keywords, and data is very, very granular. You can see where is the money spending and what are the tax dollars, where are the tax dollars going. So similarly, in times of COVID, an alliance of citizens and civil society has started work in Nigeria and African countries to track COVID spending and whether rural communities are getting the benefits from the COVID spending. So I will not get into the details so this is my last slide. So technology alone is not sufficient. This is my key message here to open the data. You need policy and legal framework and action plans. As I show in the first slide, the example of US government, there's a legislation for that. Similarly, citizen engagement is very, very essential element of open data. Without citizen engagement, this is a half of the battle. And again, there is a downside risk, which some of my colleagues already mentioned, data protection and privacy, for example. This is part of the human rights, fundamental human rights. So when you open up your data, you are also embracing some degree of risk. So you have to take cognizant of this risk and mitigate this risk. You don't need to show medical health records of the people. Similarly, personal tax information can be hidden. And then data governance. If you open your data has to be complete. It has to be high quality. It has to have some ownership, who is responsible and who is accountable for this data. And there are several other dimensions of data governance, which is, I don't want to cover all those dimensions, but data governance is very important. Otherwise, people will lose trust if the data is not of high quality and you are showing this data to the public. And again, technology is the last piece. You have interoperability and open APIs and machine readable formats and open licensing. All these are essential components of the technology. But again, policy framework, citizen engagement are critical complements to the technology. So my last message before I close my session is that open data improves trust, and which is essential for government effectiveness. And technology alone is not sufficient. You need to have policy framework and citizen engagement. Thank you so much.
Большое спасибо, господин.
Thank you very much, Mr. Huram Farooq. It was really interesting. And the concluding presenter of our session is the presentation by Veronica Gaffey, who is the chair of the Regulatory Scrutiny Board. And her presentation is the role of the Regulatory Scrutiny Board of the European Commission. So, Veronica Gaffey, the floor is yours.
Thank you very much, and thank you very much for the invitation to address you this afternoon. I come at the theme from a slightly different angle to other speakers, but I will touch on some very similar issues. So I am chair of the Regulatory Scrutiny Board of the European Commission, and I was asked to talk to you this afternoon about the role of the board in the process of lawmaking in general at the European Union level. So I'll describe the role of the board and tell you where you can find more information if you're interested. The board was established by the President of the European Commission in 2015. It replaced an impact assessment board which had a part-time function, whereas the Regulatory Scrutiny Board works full-time in scrutinising impact assessments and evaluations which accompany all proposals for European Union law. The decision establishing the board states explicitly that members of the board are independent and they shall not seek or take instruction. The board is made up of a chair, that's me, at the level of Director General of the European Commission, and we have 3 members recruited from inside Commission departments and 3 external members. They are recruited on the basis of their experience and expertise in impact analysis and evaluation, and their appointments last for a maximum of 4 years. Every proposal for a new European law must be accompanied by an impact assessment. And the impact assessment outlines the evidence on the issue the law aims to tackle. Options for action are outlined and their impacts are analysed with a view to supporting the political decision to be made by the Commission. All impact assessments are scrutinised by the Regulatory Scrutiny Board, and the role of the board is to ensure that the Commission proposals are based on the best available evidence and in full knowledge of stakeholder views. In case of a negative opinion, the Commission department responsible must undertake further work on the impact assessment in line with the board's opinion. In case of a second negative opinion, the Commission may decide to proceed, but it must explain transparently, publicly, why it's doing this. When the Commission adopts a legal proposal, the accompanying impact assessment and opinion of the board are published too. Scrutiny by the board takes place at a particular point in time in the policy cycle, before the College of Commissioners takes a decision on a political initiative. There are quite a few more stages before EU law has an impact on EU citizens. The co-legislators, the European Parliament, and the European Council also have their input. And finally, of course, there may be changes when member states transpose EU legislation into national law. The role of the board is to ensure that the process starts well. The workload of the board varies depending on the life cycle of the Commission. The current Commission came into office at the end of 2019 and announced all the initiatives that it wished to put in place over the next 5 years. This meant that from the middle of last year, we started to be very busy because that's when the proposals start coming through to give effect to all the priorities of the Commission. So this has led to a significant increase in work for the board, which is further increased in 2021. In 2020, the board scrutinised 41 impact assessments and 46% received an initial negative opinion, which meant that the Commission services had to go back and undertake more work. Already in 2021, we have scrutinised 25 impact assessments, including a very intense work recently on the package which will become the climate laws, which should be published and adopted at the middle of the year. Finally, because I know we're running a little bit late, if you're interested in our work, we published our 2020 annual report just last week. In it, we provide detailed analysis of the quality of impact assessments. We highlight the strong and perhaps even more importantly, the weaker aspects of the reports. And we do this in the interest of giving feedback to the Commission departments on how they can improve their proposals for EU laws. So if you want to find more information on the Regulatory Scrutiny Board and you're interested in our work, I suggest the easiest way to find information is just to do a Google search on European Commission Regulatory Scrutiny Board. So I know you want to have some time for questions and answers, so I'll stop my presentation there and thank you very much for the invitation to talk to you. Thank you.
Большое спасибо.
Thank you very much, Ms. Veronica Gaffi, and special thanks for saving time for our question and answer session. Those who are in attendance here and those who take part remotely, I'm happy to declare that we have reached the final stage of our session, and now we are ready to open Q&A session. And you can express your own opinions, you can ask questions, so all speakers are at your disposal, our wonderful speakers, I would say, and those who are in the presidium of the forum. I think that 3 minutes will be enough to ask your questions, and I think that maximum 5 minutes will be allocated for answers. So, and I'm happy to give the floor to those who want to ask questions. In order to warm up, I want to ask my first questions. You know that Mrs. Kevorkian took a lot of time, and she has something to say. Madam Kevorkian, I would like to ask you the following question. So in contrast to, we all say that openness is necessary, it's a very important tool or means. Let's think conceptually up to what extent, up to what level it should really exist, because currently, in order to provide openness for digital platforms, the public authorities spent a great deal of money. So promoting openness, particularly responding questions from citizens, which were much less, and in order to ask a question, one needed to come or write a letter, mail it to the agency, and these applications were not that many. But now we have virtual portals and sites. And very recently, I read an article of one Japanese scientist who substantiated that, and who tried to prove that even now, in many countries, the requirements towards openness, they impede effectiveness of performance of public agencies. So when we talk about the rights of humans to receive information on public activity, when we talk about the trust. But anyway, is there any limit? Or we should increase openness all the time, cameras everywhere, exchange of information, open data, or there's some level we may say that this openness of budget data, decision-making, transparency, and promotion of citizen engagement. What's your opinion on this? Can you hear us?
Well, yeah, thanks. Yeah, I'm sorry again for kind of abusing the time earlier. Well, I think we are dealing with the phenomena with kind of like two evils almost. It is important to keep that openness, and of course there is this practical issue of people turning to authorities, to governmental officials to have information, and you are quite right, that might sometimes also inhibit the effectiveness of the work itself. However, I think in that respect we do need more data on that as well. This is an assumption perhaps, but also you are right that it has increased with the digital world, and people are more comfortable perhaps even asking questions and information from the government. However, I do not see there is a good solution to this either than just to try to make government more efficient, because information is necessary for people to have to make informed decisions, to also contribute to exactly this word trust about governments. How can I trust the government who does not provide me information? For example, in Estonia, I can turn to any authority, I mean governmental authority, asking questions. Well, they cannot be just random, like let's say, what time does the sun rise tomorrow? That would not be probably answered, or answered in a very very short way. But anything concerning data on me, or some of official position, they need to answer in 30 days. So there is that 30-day requirement for the reply. It also contributes to transparency, and I think it also avoids corruption. So you can have that data open and you can ask that. But for the effectiveness, I think it could be also that technology in the end can also provide some answers. For example, we are talking these days, even in the digital world, that some simple legal cases are solved by algorithms. So you do not necessarily have another person on the other side, but a system also helps you to solve some legal issues. But it is an interesting world, let's put it this way, and I do not perhaps have a perfect answer to it, but there are let's put it short, then negative and positive sides of it, but I see more positive sides to this openness and which contributes to human rights, but also making business, because how you trust the government also contributes to the effectiveness of the economy and development, as one of the goals of the UN as well.
Большое спасибо нам.
Thank you very much. It was very helpful to hear your opinion, and I would like to inform you that we also in Uzbekistan, till the last time, we had the requirement to respond to the citizen request within 30 days, and now legislation defined must respond by 15 days, and if it's a media or a press request, we have to respond. The government have to respond up to 7 days. I saw somebody had a question in the auditory. Okay, go ahead, please. Could you give me a microphone? The lady on the back row had a question. So, good afternoon. Could you please introduce yourself? My name is Zhakhnoza. I'm a Senior Consultant, Organizational Control Department of the Ministry of Justice of the Republic of Uzbekistan. And dear moderator, my question is kind of similar to yours, but I would like to ask Marilyn from the Maryland and Mr. Lori Melkso, who is also professor who is in his speech mentions that in the digital world there is certain moments could happen fact of corruption even in the digital world. For example, now commercial and business, in order to benefit commercial organization or business, in order to sell in the financial interest to their user database, their servers, and just Madam Marilyn mentions that corruption. Maybe with the corruption, it is a low level of corruption. Would you get a certain paradox in this case? Yeah, Madam Kiori, it is your benefit, so the floor is yours. We're expecting. Are you here?
got everything because there is a very heavy echo. I think somebody's microphone is open. It's very bad echo at the moment.
Господин Мелска, может быть, услышим.
If you can hear me, then what I gather, there is this problem, and we have kind of flashed through it as well to a little bit, and the panelists touched upon this issue one way or the other. This question of data collection, and data collection also by the companies, and obviously there is some sort of regulation needed, and perhaps even sort of globally discussed, because the companies are functioning in multitude of countries, not just in one country. And the more open the state is, you have also multinational companies functioning in the country. And this data collection is problematic, let's face it, and not even people know sometimes what they agree to give to companies. So the question here is a very delicate one, I think, that how far can state go to say that or protect a human being, if I'm coming from the human rights perspective, that to protect a human being from that harm, if she or he willingly is clicking this, yes, I accept this and that, so it almost becomes like a private contractual relationship between the company and the individual. However, if that data is sold on, used and abused for different other purposes, which were not necessarily consented to, or were not explicitly made clear to the user as well, that why I'm giving it up, or what is going to be done with this data, for example, afterwards, then I think that is we are at that point where we do not have yet an ideal solution, and that's I think one of the reasons why we're discussing about that as well. So I cannot offer it on the plate to say what the solution be, but for the more the data, I did like that point by Mr. Forgood, that that more data is better. We have more information available and open, and we can also then discuss it. But with the companies, of course, it is an issue, and we can have perhaps there have to be some clever ways how to deal with it, not to jeopardize the openness and human rights and good governance at the same time.
Господин Мелск.
Mr. Melska, did you hear the question? Can you answer?
Lauri
Melksa, are you here? Are you online? As I understand, switched off. So, okay, anybody else would like to answer to this question? Good afternoon. I would like to express my opinion in the issue of the open data, open government, or the state authority, or any public institution, as I said. And about the openness, I think that those presentations that we had in the beginning about the UK UK practice.gov UK, that it is a great example that we need to achieve. The openness doesn't mean that we have to all information to open and to provide it. We have to learn how to provide this information. Why I'm talking about this? We have a Lexus website with it means that anything new in legislation, any person can visit the website and review. But besides the legal professionals, nobody really visits LexU's website. And the fact is not that we're providing all information as open, but we also we should provide it in a proper way. In this particular, the practice of UK practice is a good example, great example, because it doesn't set according with the article such and such about education of such and such. No, they put information, they put a question for the, or a headline, what should be done that your person get enrolled into the school. So, okay, you get a list of documents and you need to provide to such authority. So I think to simplify the measure, this we can attract people, citizens, to understand, to be more loyal to the government authorities. Yes, we do have official websites of the government authorities, and then you get lost. Once you visit them, you cannot understand anything. I think it should be simplified. It should be easy for a person. It should be a first-time visitor would get a clear idea where you need to go and how to get. I think it should be criteria. One of the criteria that the government should work on his open government. Another issue in the human rights and human rights protection in the now time, in the modern time when the internet is covering worldwide, now the person who has a driver license, it must know his rights and his duties, and the human rights is been established by the civil and political rights. In the 19th article of this pact is to talk about that everybody has a right for the freedom of speech, and nobody and nothing should be limited. But the second part of this article is talking about so local legislation could have limitations for the open speech that could affect that's against of the government or could affect other people. So for this particular point of view, I think we need to review not all local legislation, but also international conventions, just the following, and just include this Internet of Things related. Those have become a daily routine, but we don't have any coverage in the any legislation. The Internet of Things is not covered at all. Thank you very much. Thank you very much for your opinion. What is related to the lex.us website, I think such a detailed database provided in electronic free of charge. Not every country has such a website. I also would like to underline that this is a national database of the Uzbekistan of legislation, and the status is reflected in the legislation. And the use of this database has a legal right, because I'm as a deputy, been in the Tashkent region as a farmer using the mobile telephone with lex.us website and demanding his right, because in the mayor's office and regional mayor's office, and he demanding to protect his rights, because I think not only lawyers or legal professionals are using the lex.us website. It's not a news site, but people that are visiting lex.us, they hitting a lot of pages. So it's visited a lot. So and people, citizens using website a lot. They do not leave website after the second or first click. Also, Internet of Things. Internet of Things. I think we're not gonna cover the freedom of speech for the refrigerator. That's the eggs bin. That's you ate all eggs. That you need to replace the batteries in the car. So we're not gonna. It's a helpful things. But now when we talk about the freedom of speech, we mean people and not Internet of Things. And this way, local legislation is on the international level. And I think that we are on the good position in this relationship. So we in the Parliament keep track with a big attention, and what is related to the amendments, we need to limit this, we maybe should forbid this. No, we look on this precisely, and we cannot touch these things. The freedom of speech is guaranteed by constitutions. We need to leave it as it is, as it's already working. Thank you. Thank you. If anybody else has any questions yet, okay, please. Okay, the microphone is off. Yep.
Good evening, International Forum. Thank you for experts for their useful presentation. We got a lot of useful information. I have a question to Mr. Mark Bir-Obe.
Please introduce you. Представьтесь.
My name is Anvar. I'm a senior consultant in the Ministry of Justice, Republic of Uzbekistan. You mentioned the effective use of digital opportunities in order to reduce the costs in the criminal justice system. We know in some countries in the world, juvenile offenders are brought under public-based supervision in order to reduce the negative impact on their moral and reduce also the costs of prisons. In some countries, offenders are subjected to enforcement measures such as the installation of monitor bracelets. It has also yielded some effective results in some countries. And what are the technologies and methods do you recommend in this field? Mark Bir-Obe.
The question was addressed to Mr. Mark Bir-Obe. Mark Bir-Obe, do you hear us? Mr. Mark Bir-Obe, do you hear us? Do you hear us?
So yes, I hear, but the translation isn't clear, so I'm afraid I didn't hear it.
Да, и вопрос был достаточно, может быть, не очень близко по вашему.
Yes, and maybe the question was a kind of maybe not related to you. I will ask to repeat the question and to shorten it. So,
what kind of methods and digital opportunities do you recommend in order to reduce the costs in the criminal justice system?
Well, if I may, I think that's an excellent question. The point that I was making was that by using technology to increase public trust and confidence in the police system, in the criminal justice system, and by getting the citizen effectively to want as a norm to follow the criminal justice law, then that in itself has a significant impact on the criminal justice system and the operation of it. But after that, when you're left with, unfortunately, some criminals to deal with, what we're finding around the world is that technology is much better at predictive outcomes. So should somebody be released on bail? Does somebody still present a threat to society? Is somebody likely to commit again? The analysis of data sets, although as the World Bank pointed out, they would need to be organized, allows for judges and parole officers and probation officers to much better predict the likelihood of somebody committing a crime or repeating a crime. And that's an area where we're starting to see technology performing up to 41% more accurately than human judges. that takes a lot of the headache away from the system. Now, yes, there needs to be checks and balances. Yes, there will need to be humans in the appeal process. But it does mean that those who deserve to be out in society, endeavoring to get work and to improve themselves, who have made a mistake, are allowed to do so, and those that present an ongoing danger can't. So that seems to me to be an obvious area where technology can assist. But the biggest impact of all in technology is by using it to improve public trust and confidence in the system overall. What you find is that law-abiding citizens, or lawfulness, goes up so significantly that it allows the criminal justice system to focus on perhaps those that are, serial criminals, rather than trying to police the average citizen for speeding offences and for, much more minor offences, which tend to occur when citizens think that the law doesn't apply to them, or that the law is not something that is there to help them. So I think that's the real focus of technology, is encouraging the whole of society to act in a more lawful way.
Thank you.
Если позволите, Ильхам Заирович, у меня было пару ремарок, потому что действительно очень интересная тема была выбрана. Могу сказать, что по...
And I may say that as every presenter deserves a separate discussion, because they raised very important issues, and it proves information technologies are becoming not just a necessity, and they become daily routine thing in every family. As soon as a child is capable of holding some things like telephones, smartphone, that a child can live one's life just at home without going outside, and that our mobile applications helped us live our life without leaving our place. And information technologies are filling our life. And speakers also meant that digitalizations and the capacities of information technologies ease our life. And another proof for this is our forum, that during pandemic, if there is no chance to participate offline, so we can provide online participation of people, remote participations, and we have a chance to organize this dialogue to discuss crucial problems. On the other side, we also say that information technologies add responsibilities to everyone, not just government. And we can see, the first presenter mentioned it when he said that it was Jude Hannan who talked about British experience. She pointed out that information should be of high quality and should be timely and veracious, and the information we provide using information technologies, we should be responsible for, and we should try this information, and it should be veracious, and only in this case it can bring some good. And the red line of every presenter was the refrain that on one side we need to promote accessibility, on the other hand we don't say do not harm by providing openness. Yes, we talk about openness of governments, and in this regard we have done a lot. In the very beginning, in the introductory remark, Ilham Zairovich mentioned the law which was recently passed on openness of public authorities' performance, and I would like to draw your attention to the strategy of Digital Uzbekistan 2030, which was approved by the presidential decree. According to this document, a lot is being done, and Cabinet of Ministers resolutions which regulate certain measures to provide openness and provision of data. But as the President pointed out in his performance and in his state program, we need to do a lot. And the public procurement specialist Eliza Nevidomska it was interesting to listen to her opinion, and she said that taxpayers have the right to know how their dollars are spent. And in our country, it's becoming more and more important. I mean, tenders and bidding procedures and public procurement. And in order to resolve this issue, we are implementing one tax which was imposed on our agency, on our anti-corruption. This is the development of applications which could provide more transparency. It's how to expand the list of the data which are subject to open publications, and it includes data on tender committees which are formed for public procurement. And by this, any individual will have the right to know how these tenders are conducted, not only for public procurement, but for investment projects as well, and other issues which represent a great deal of interest for our citizens. And in this regard, we need to point out another thing which was mentioned by Ilham Zairovich, to what extent openness should really exist, whether there should be a provision on adequacy. And the analysis of citizen applications prove that there are so many unnecessary, inadequate applications, but anyway they're considered, and they really take away time and waste resources, and they really distract people from resolving very important issues. And sometimes people just provide formal response without, and very often people write their complaints to any instance, to any agency, and this is how they clog the paper turnover. And I would like to support our Minister Ruslan Davletov, who in his introductory remark pointed out that digitalization is a very important part of our life and our public activity, and we need to define priorities as to where to direct our resources, because it's a multifaceted thing, because digitalization covers the entire all the aspects of our life, and we need to determine how the priorities we need to develop and what we should invest our resources into. And so what is the limit of openness, and what should be the interaction, and how to observe human rights in this context? And this is why there should be some conceptual solution and practical solutions coming out from analysis of real life. And it is pointed out in the 2030 strategy. It is informational literacy, training of personnel, and creation of information programs which will be implemented, and legal literacy and legal culture is also important. But with the development of digitalization, it becomes more and more actual, because only when legal literacy is in place, it will be possible to talk about non-violation on someone's right, because where rights of others start, your right ends. And you need to know this demarcation line, and you should correctly use the right granted to you. And I would like to support the representative from the Ministry of Education who said that it is, if I understood it correctly, that we need to prepare answers to most common questions in advance, and a great deal of work is undertaken by the Ministry of Justice. But you should agree that with the development of digital technologies, lawmaking process encounters more and more issues and challenges. This is why we need to take our finger on the pulse, and we need to follow and closely monitor what is crucial for today's life, because what was crucial for yesterday becomes obsolete today. This is why we talk about training people and rule of law. Only when rule of law is promoted and provided, we can say that information technologies will be used in favor of the society and the state and each particular citizen. And I would like to make another remark to Mr. Lowry. He reiterated several times the phrase that Big Brother is watching us and he can violate our rights. And I must say that Big Brother is ahead of your predictions, because Chinese experience shows that utopia 1984 stops being a utopia, and based on Chinese experience with the implementation of a system of secure town where information technologies, when you just cross the border city line, your full information about all your movements and your personal data start being stored in certain information application and software. This is why we need to talk about personal data protection, and we should tell you that Uzbekistan is ahead of many other countries, and in 2019 we have passed the law on personal data protection. So as we see, just summarizing, I'm a teacher and maybe I'm very much talkative, so I would like to conclude by saying that information technologies and openness of our government, we need to fully comply with things like culture, legal literacy, and only then we can be able to say that digitalization will be in favor of our country. Thank you very much. Who else would like to say something, because we have the last 2 minutes, and then we will conclude our today's session. So concluding our today's session, I would like to say the words of gratitude to our speakers. It was very useful and interesting. Maybe we didn't have much time to start discussing, and so that they would understand how attentively we were listening to them and how seriously we take the information. But I would like to assure you that your presentations were very useful. And besides, I'd like to express my heartfelt gratitude to the organizers, to the OSCE and UNDP and the Ministry of Justice, who for a long time were demonstrating high examples of provision of transparency, and they're taking leading positions, and they try to direct our government and other state agencies in the direction of legal protection of our citizens. And the main message we received from today is that digitalization by itself and digital platforms do not provide openness and transparency. There should be some legislative basis for this, and there should be policy measures, and there should be active citizen engagements. Without this, we cannot attain our goal. We also mentioned COVID, which made many problems very sharp, and we were able to adequately respond to this challenge, so that in order not to violate citizen rights. And this is the level of digitalization which has been present by then, and it became the foundation to the fact that we managed to provide openness at the level of our legislative requirements. Of course, there are some shortages and drawbacks, but anyway, there's a big positive thing about all this, and all measures with regard to digitalizations and openness, and assessing our political course, we need to understand that this is the consequence of the leadership positions and those directions which are determined by our president, Mr. Mirziyoyev. We should be all clear that our president, in his message and in many and in many resolutions and decrees he passes, which are aimed at the digitalizations and promotion of openness. I think that this work will never stop, and it will subsequently provide its fruit. By concluding, I would like to say that we have legal people here, and in one of the presentations it was said that one of the criterion of what is openness is the matter of access. But you know that in Uzbek language we don't have an adequate term for the word access. Even in our legislative acts we use erkim foydalaneshi, such a term, but it's not exact translation to the word access. And so this is one of the tasks for you to think it over, so that we could invent such a term. Thank you very much for your attention, and goodbye.